Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 6.5 hours of argument this afternoon, so please keep that in mind. What? I don't know if you heard any of that, so good afternoon again, and welcome to the Appellate Division, First Department. We have some 6.5 hours of argument this afternoon, so please keep that in mind as I call the calendar. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your cases. And with that, I'll begin. People versus Donald McGreer. Uh, 5, 2, and 5. Thank you. Genesis Company versus Popple. I didn't hear you. And that's everyone, right? 5 and 2, 5 and 2, and 7. Alexander B., thank you. Alexander B. is submitted. Think Forward Financial versus On the Level.
Respondent 7.
Is that everyone? 5, 2, 5, 2, 4, and 2, and 7. Thank you. Lopez versus Helletz Astoria. Five and 2, 5 and 2. Thank you. FTF Lending versus Mavrides. 5, 2, and 5. Thank you. 644 East 14th Realty versus Mount Sinai Health and Hospitals. 5, 2, and 5. Thank you. People versus Keith Barner. Submitted. Salinas versus Dorian's Restaurant. Okay, you're going to have to give me that again. I'm sorry, if you could keep your voices up. Okay, 5 and 1, 5 and 5, thanks. People versus Alexander Ruiz. 5, 2, and 5, thank you. Ontario versus Lehman Brothers is submitted. Caso versus Urban Builders. Is there somebody up there? Five, 2, and 5. Thank you. People versus George Garcia. Five, 2, and 5. Thank you. Mazzarisi versus NY New York Society. Okay. 5 and 2 and 5. Petri versus Lucia. I beg your pardon? Yes, okay, I believe the calendar says 2, so we'll start with that. 2 and a submission. There's no one else here. There's no opposition. Thank you. 140 West 57th Street versus Berry.
For appellant 5 and 2, please.
5, 2, and 6. Gordon Law versus Premier DNA. Submitted. And Roberts versus Rogers and Hammerstein. Five, 2, 5, and 2. First case for argument is People versus Donald McGreer.
Can I proceed?
Yes.
May it please the court, Josh Glasser from Weil, Gotchel, and Manges with the Office of Appellate Defender for the appellant, Mr. McGreer. Mr. McGreer's conviction should be reversed because the trial court erred in denying Mr. McGreer's requested instruction of third-degree assault as a lesser-included offense of both first-degree assault and first-degree gang assault. There is a reasonable view of the evidence that Mr. McGreer did not intend to inflict serious physical injury.
But was there a reasonable view of the evidence that he didn't have a dangerous instrument? And isn't that required, at least for the gang assault, I believe?
That is not required for the gang assault. The dangerous instrument is only required for the first-degree assault.
Okay, so for the first-degree assault?
Yes, for first-degree assault, it requires a gang.
So is there any reasonable view of the evidence, given the video, that he didn't have a dangerous weapon for the first-degree assault?
Yes, Your Honor. That's because a belt is not a dangerous instrument as a matter of law.
But it wasn't the end of the belt, it was the buckle of the belt.
Yes, Your Honor, but a buckle, too, is not a dangerous instrument as a matter of law. A dangerous instrument has to be capable of causing imminent death or protracted disfigurement, and here, the way in which the belt was used, the only testimony about the way the belt was used is that it was hit a lot of times.
But wasn't it all focused on his head? Wasn't it all focused on the victim's head?
Yes, Your Honor, that's not the testimony with respect to Mr. McGreer specifically. The only testimony from Norberto, the only witness of Mr. McGreer, is that he swung with belt and buckles enough times. It's incredibly vague, Your Honor.
The way in which it was being used, whether it was hitting him in the head or hitting him on the body, the way it was being swung many times, could be a dangerous instrument in the way it was being used?
Your Honor, frankly, the way a belt is used, you might expect a scratch or maybe a welting for a few days.
Well, there wasn't a scratch.
More than a scratch, but certainly not.
We can agree that certain items in their use and the fact that they're readily capable of causing certain serious injuries can be considered dangerous instruments. Just because it's a belt that you would normally wear around your pants doesn't mean that once somebody wields it repeatedly, hitting someone with a buckle, it then turns into a dangerous instrument.
But, Your Honor, a dangerous instrument needs to be capable of causing serious physical injury, and serious physical injury is substantial risk of death, serious and protracted disfigurement, and protracted impairment of function of body.
Also, that's having the capability to achieve those results, not that those results are mandatory or required, correct?
Yes, but in the way in which it was used. Yes, it's capable of achieving those potentially if it's used to strangle
So is it your argument that he didn't hit him enough times with the belt, that therefore it didn't reach the level of being capable of causing serious injury or death?
Yes, as the jury verdict shows, the jury found that he did not inflict serious physical injury. He and the others did not inflict serious physical injury because by acquitting him of the first-degree charges and finding him only guilty of the attempt charges, they found that he intended to inflict serious physical injury. But our argument is that a reasonable view of the evidence is that he only intended to inflict physical injury given what a high bar it is for serious physical injury under our statute. So yes, the testimony is incredibly vague. He hit him enough, a lot of times. If, as Your Honor was suggesting, there was testimony about the ferocity with which he was hitting with a belt, if there was testimony about the whipping motion, if there was testimony about strangulation, then we might have serious physical injury or the belt as a deadly weapon or dangerous instrument. We have none of that here, Your Honor. So to me, this is a pretty straightforward because it's just hitting with the belt a few times, potentially, just enough. It's incredibly vague, Your Honors. So the intent, if there's no intent to inflict serious physical injury, that gets him third degree as a lesser included offense for both first degree charges. So I think that's significant, Your Honors. And again, I remind you that you have to look at the light most favorable to the defendant in this situation.
Thank you.
Good afternoon, and may it please the court, Jennifer Westfall for the people. Just to start with the intent portion of counsel's argument, just because Jeffrey supposedly did not suffer or incur a serious physical injury does not mean that the defendant could not possibly have had the intent to cause serious physical injury. That argument is backwards. While assessing intent, jurors are entitled to presume that a person intends the natural and probable consequences of his actions, not the actual consequences that result. Here, hitting somebody in the face, near the eyes, near his mouth and his teeth and his ears, that's dangerous. That could 100% cause serious physical injury. It could cause blindness. You get hit in the eye with something metal.
Oh, but you're not just hitting him with the belt buckle, is what
Yes,
you're saying.
he was
right?
hit with a belt buckle. And I would just like to say that the evidence is not incredibly vague. First of all, both Exhibit 1 and Exhibit 2, you can see defendant wielding the belt. In Exhibit 1, you see him pulling it off as he starts running after Jeffrey and his friends. In Exhibit 2, it's very brief, but as they're passing, you can actually see defendant swinging the belt at the person directly in front of him. Norberto also testified that he saw Jeffrey specifically being hit by the belt buckle by defendant. He stated that he could not see Jeffrey while he himself was being beaten, but he clarified that he saw Jeffrey being assaulted both before and after he was able to escape his own predicament. Therefore, there's simply no reason for the jury to conclude that Norberto was not an accurate observer, that he couldn't have seen the belt buckle being used. And I would suggest that being hit so many times that you can't count and you can't keep track in the face with a belt buckle, 100%, it gives us enough information to know how that belt buckle is being used.
Well, counsel, there's nothing in the law that requires a minimum number of strikes, right? It's possible that striking someone in the face with a belt buckle could cause serious injury, even potentially death, just with one strike. Is that
Of course.
right?
Yeah, you get one lucky hit to somebody's eye, there's your protracted disfigurement. Yes, I don't think there's a certain number of strikes that defendant needed to hit. With respect to the other points, the hearing court correctly determined that the show of identification procedure was proper. The trial court appropriately permitted the people to introduce the videotape of the clothing experiment and also properly permitted the people's expert witness to explain the color-changing phenomenon evident on the infrared camera recordings. Finally, defendant's sentence was fair and appropriate and should not be disturbed on appeal. If there are no further questions, I respectfully request that you affirm.
Thank you.
Thank you.
Your Honors, I remind that the test here is whether a reasonable view of the evidence in the light most favorable to the defendant suggests that the defendant did not intend to inflict serious physical injury. And especially when viewing the light most favorable to the defendant, I think it's clear that he did not intend. The question is not whether the jury would find the defendant guilty, it's whether the defendant, or whether the jury could find him guilty of the lesser but not the greater offense. And I think because the lack of specificity makes it clear that a jury could likely, or just could find him guilty of the lesser. The people referenced the evidence here. The video from before, it's from before the attack. And the video of Mr. McGreer swinging is against someone else. So the only testimony about Mr. McGreer's specific acts to the victim, Jeffrey here, is from Norberto, who himself was under attack, and he said he could see this much. This much, what does that mean? He hardly saw anything. So if he's under attack, his perception was totally distorted. And Your Honors, our two other issues, which the people touched on briefly, are also very significant. The show-up identification was unduly prejudicial and impermissible, given officers' comments from before the show-up saying, if you don't make an identification, your brother's death would be in vain. Your brother's death would be for no reason, and Norberto was desperate to be at the hospital by his brother's side. That's significant. Norberto wanted to attend to his brother, and as long as he made any identification, just any identification, he could go back to his brother.
Did the record indicate that he took his time when he saw the people? He didn't just say, that's the person, take me to the hospital, but he did look and take his time to make the determination.
Yes, Your Honor, he did look and took his time.
There was more than one person stopped by the police, wasn't there?
Yes, Your Honor, there were three, and he only identified.
He identified only one.
Yes, Your Honor, he identified just one, and he only needed to identify just one in order for his brother's death not to be in vain.
And I don't know that the language used was, we need you to come and make an identification. I think it was, we got a group stopped of potential suspects. We need you to come and take a look and see if this could be them, or something to that effect.
Your Honor, after a group was stopped, they said that at one point, but he also said, help us catch who did this to your brother. Who did this to your brother implies that the people stopped were, in fact, who did this to your brother. So it was saying, help us catch the people who were stopped. If you give
Well, anytime you go to a place where you're potentially making an identification, the understanding is that one of those people could be the suspect. It doesn't mean that they will be or they are.
But
That's the whole purpose that he went to this place.
Right, and he identified someone so his brother's death would not be in vain, and so he could return to the hospital to check on his brother, who he was desperate to see. So I think here the officer's comments weren't just, all right, there are people stopped, let's see if it's, like Your Honor said, let's see if these potentially are the people who did it. It was, your brother's death cannot be in vain. If your brother's death might die for no reason, yeah.
Thank you.
I mean, it was also clear that Norberto's, his perception was altered given his brother left that day from the hospital.
Thank you.
Thank you, Your Honor.
I understand that you are from Weill Gottschall. We appreciate you doing this pro bono. Thanks to you and your firm. Thank you both. Genesis REOC Company versus Stuart Popple.
You needed a pillow, right? That's what I was going to
May it please the court, good afternoon. Gregory Bennett on behalf of defendants appellants Stuart D. Popple and Popple Law LLC. The defendants appellants Stuart D. Popple and Popple Law LLC respectfully submit that the trial court's order denying his 3211A7 dismissal motion aimed at the plaintiff's respondent's legal malpractice claim against him should be reversed because the allegations in the plaintiff's First Amendment complaint.
Is the basis of your argument that the settlement with Hudson obviates this malpractice action?
I'm sorry, Your Honor, I didn't hear you.
one of the prongs of your argument, or your main prong, that the settlement with Hudson obviates this malpractice claim against your clients.
That's correct, Your Honor. Not once, but twice.
Doesn't this action, plaintiff wasn't made completely whole with the Hudson settlement.
We don't know, Your Honor. The plaintiff's respondents made a decision to sue Mr. Hudson to make themselves whole.
So if you don't know, wouldn't that in itself be a reason why this 3211 motion shouldn't be granted?
No, Your Honor, respectfully. There is no allegation whatsoever in the First Amendment complaint implying or suggesting that the settlement of not only the first action that Mr. Stone's entities commenced against Mr. Hudson, but the second...
This action was started before the Hudson action, right?
No, the first Hudson action was commenced initially, then there was a second...
This action was started in July 2017, right?
Yes, that's correct, initially.
And when was the original Hudson action started?
I believe December 2016, Your Honor.
And the second Hudson action?
That would have been on January 15, 2019.
So this action predates the second Hudson action?
The second, yes, that's correct. The reason for that is because after the first Hudson action was commenced by Mr. Stone and his entities, they entered into...
They didn't get paid?
We don't really know exactly, yes,
We're not
as far
sure
as we
what
understand.
they were supposed to get.
That's correct. After that action was...
But by the time they settled the second action, they put an amount in, like 3.2 million, but the claim in this case is for much more than that.
That's correct, Your Honor, but the claim against Mr. Hudson in both of the lawsuits that Mr. Stone commenced against him was for the full panoply of claim damages that they were seeking, roughly in excess of 40 million. They elected to sue Mr. Hudson alone, not once, but twice. They also elected to separately settle with him on 2 separate occasions, and they still seek to recover the same form of damages.
But I mean, the first Hudson settlement specifically provided that it did not fully compensate plaintiffs and that the release did not apply to your clients or to, your co-appellants. So they specifically, wrote that into the settlement agreement. So how could this obviate it at this
There was language in the first settlement agreement carving out the claims, purporting to carve out the claims to allow them to continue to pursue damages against co-defendant as well as my client, the Popple defendants. However, there is no allegation within a legal malpractice claim when you are trying to base or recover damages arising out of a matter that is settled. You must allege that but for the alleged actions of an attorney, the plaintiff seeking recovery in a legal malpractice claim settled on disadvantageous terms because of those acts or omissions. After they settled, not only the first time, but the second, there is no allegation in this complaint that the settlement was affected or even caused indirectly in any way by the Popple defendant's acts or omissions. It's totally missing from the first complaint.
aren't the but-for... I mean, I know that that's what the standard is in a legal malpractice claim, but they're not suing for malpractice arising out of their actions in relation to the settlement negotiations, but it comes from a prior action, and that's what they're claiming is the malpractice.
That's correct, Your Honor. And with respect to Justice Edmeade, who was at the trial court level, respectfully, I believe she did get it wrong in applying the settlement line of cases in proximate cause analysis and legal malpractice claims. That proximate cause analysis is not applicable only when the attorney is actually serving as counsel in a litigation. In the Bernstein case, which is a First Department case cited in the moving brief, my client's papers, in that situation, the First Department was construing allegations on a 3211 motion which related to alleged acts and advice that occurred before suit was commenced. And they found the allegations themselves because the complaint said, but for these X, Y, and Z pieces of advice, I would have gotten a better settlement.
So but for the specific acts of malfeasance of the defendants, that wasn't enough? They said, but for those specific acts?
No, the First Department said in that instance that those allegations were sufficient.
I mean in this particular case.
There are no allegations that we had anything to do with the settlements. That's the point.
But Stone at page 181 of the record sets forth 4 distinct ways in which what is being sought in this action differs from the Hudson settlement. Why isn't that enough to survive this 3211 motion.
I'm sorry, Your Honor,
Page
181?
181 of the record.
Yeah, Your Honor, actually, that's a page that I earmarked as well. Paragraph 23 on 181.
Paragraph 22.
Excuse, paragraph 22? Okay.
And 23 says he entered into negotiations to resolve some but not all claims arising from Hudson's breach of the agreement.
And that's sort of the point we're trying to make, Your Honor. He sought recovery to make himself whole from Mr. Hudson, and he made an intentional decision.
And he says he didn't.
To discontinue it.
And he says he didn't.
These are the same forms of damages that they're seeking. They might be described differently in terms of the facts, but the forms of damages and the remedies are identical.
Thank you.
Thank you.
May it please the court. My name is Edward Copeland, and I represent appellants Charles Williams and Picard and Abramson. My colleague, Mr. Bennett, addressed one of the issues that we raised on appeal, and I will, unless the court has particular questions for me, I will deal with the issue that is particular to Mr. Williams and the law firm, which is whether there is sufficient allegations of an attorney-client relationship between Williams and the...
Williams was originally Hudson's lawyer, is that correct?
Williams was Hudson's lawyer, yes, Your Honor. And the allegations in this case, when you look at it, the First Amended complaint against which the motion was originally filed had really nothing other than a bald statement in paragraph 23 that all these defendants represented.
But in opposition to your 3211 motion, the plaintiff submitted an affidavit for Mr. Stone, and which they are permitted to do on a 3211 motion. And didn't that affidavit describe in some detail Mr. Stone's longstanding relationship with each of the defendants and the agreement that your clients would represent Stone and the plaintiffs?
First, of course, they were entitled to file that affidavit. We agree with that. That affidavit, in fact, there were 3 separate affidavits. But as to Williams, which was number 5, and I think that's at 611 or so in the record, there is no history of relationship between any of the plaintiffs and Williams or that law firm. I know it's asserted in the briefs, but if you read the affidavit, Mr. Stone had never met Mr. Williams before this. There was no history of them. And while we all, and I'm jumping ahead a little of my argument, while we all have kind of looked to this allegation, because there is no retainer agreement, of whether there is sufficient allegations.
But ultimately, does Williams come to represent the plaintiff also?
No.
So
He does not, and that's the point. When you look at that,
may I just, to clarify for myself, so in the affidavit, where I thought that the Stone gave specifics in explaining the relationship with with Williams, and that they gave him advice, and that he relied on that advice, all that's not the case?
Well, one, it is not the case it is not the case, Your Honor. And what we point out with respect to that affidavit is 2 things. One, you have to look very carefully at what Mr. Stone actually says. And for example, paragraph 7 of his affidavit and paragraph 11, where they're quite conclusory and subjective. And second, what he does, and I'm glad Your Honor raised the point about these email advice that he relies on and weaves into it, and that Justice Edmey relied on very heavily. Those emails do not mention any of the plaintiffs. They do not mention Jazz Realty 2. They do not represent Jazz Genesis 2. They do not represent Genesis REOC. They are between Mr. Hudson, admittedly a client of Mr. Williams, and in there he has the name Genesis Companies under there, which was the company that was being represented. Mr. Stone, in one of those emails, is described as an investor. He was an investor with Mr. Williams, with Mr. Hudson. And that is relationship. And as we cited in the brief, on the website for Genesis companies, Mr. Stone is described as a member of the executive committee. So what we have here is these plaintiffs constructing out of a series of emails between Mr. Williams and someone admittedly a client of his, saying, oh, by the way, I was on that email because I'm an investor, I'm a member of the executive committee, and gee, you know what? That gives me a basis to somehow claim that I am your lawyer, you are my lawyer as well.
Well, he said in that page 611 to 612 in his affidavit, the reliance that they had, the reliance that Mr. Stone and his company had upon the advice of the Williams defendants for a 30-11 motion. Isn't there enough to at least let it go past that? I mean, you don't have to prove your whole case.
It's not, because in the context of him putting that forward, when you look at the emails which he relies on, and Justice Edmead relied on, the conversations that he's relying on are with Hudson and Genesis companies. If those emails said, you know, Karim Hudson, Sam's Deli, we would look at those and we would say, what are you talking about? This had nothing to do with Genesis Realty. He's using the similarity of names and a conclusory affidavit to construct a attorney-client relationship where none existed. As a policy matter, all of us as attorneys have calls now with all kinds of people, with our clients and with people who are involved with our clients and executive committee members, partners, or whatever. The fact that our client brings somebody into a conversation or they're in that does not make that person a client. You still need the undertaking by the attorney, explicit undertaking to perform a legal services, and that is what is missing.
Thank you.
Thank you, Your Honor.
It's okay. They'll get it afterwards before they leave.
Good afternoon, Your Honors. Ellen Werther, Wrestler and Wrestler on behalf of respondents. Let me first address the Williams defendants' arguments. Mr. Stone wrote an affidavit under 3211A, as the court notes. It's clearly to be given, deemed true and given every favorable inference on its face. I believe the court rendered a decision about 10 days ago directly on point. The restaurant case versus, I can't see, Consolidated Restaurant. It was rendered 12 days ago, which makes very clear the standard under 3211A1 and A7. Mr. Williams, his attorney, is raising a pure 3111A7 argument. So therefore, all of the allegations and the evidence attached thereto must be deemed true solely for purposes of assessing the validity of the claim.
Well, it didn't sound like the Williams defendants were actually disagreeing that we can read Mr. Stone's affidavit and those are permitted, but he's saying that there was not, it was Mr. Stone's allegations were conclusory and it wasn't, he was mixing up the names and it wasn't really clear that there was a legal, a legal relationship between Mr. Stone and the Williams defendant. So can you point to us where, in fact, in your opinion, Mr. Stone says enough to get us past this 30-11 motion?
Yes, Mr. Stone describes in detail how in 2011, shortly after the company was formed, Mr. Hudson introduced Mr. Stone to Mr. Williams and said, here is my lawyer. He's not my only lawyer, but he's going to be very good for us. We're going to use him together to help find transactions within this niche of the real estate market, help us negotiate them and bring them to us and represent the two of us in connection with those deals. It goes further. Mr. Stone's affidavit then goes on to describe the interview that he had with Mr. Williams and his company. He then goes on to describe in detail how he found him acceptable for the purposes, and that he then, Mr. Williams then accepted the engagement and urged Mr. Stone to rely on his advice, not just in connection with the transactions that he was finding, both in New York City and elsewhere, but also in connection with litigation that arose with various of those entities. So other than interviewing the lawyer, telling him he's going to be engaged, telling him the scope of his engagement, having the lawyer accept that engagement, and then rendering services in connection with that engagement, I really don't know what under New York law is required.
And relying on those services?
Yes, and relying on those services. It's not one page in the Stone affidavit, it's replete with allegations. And I refer your honors to the Stone affidavit that addresses specifically Mr. Williams' conduct. What was most egregious is after having done this for years, Mr. Williams then, when Mr. Stone found out that he was being robbed with the active assistance of Popple and Williams in connection with the transactions at issue, Mr. Williams refused to allow him access to the company books and records as he was allowed to do to determine the full extent of the damages. The complaint alleges quite clearly that unbeknownst to Mr. Stone, Popple and Williams were actively colluding with Mr. Hudson, who was not a defendant in this action.
So can you address the first attorney's argument that the fact that there were two settlements in two different cases against Mr. Hudson does not preclude this case? That was a big part of his argument.
With all due respect, I think he's absolutely wrong. Please, the court, please think of this as mitigating damages. If my client, Mr. Stone, had not attempted to mitigate damages, that would be an affirmative defense to dismiss his claim. What he attempted to do, and it is alleged in the complaint, that the defendant lawyer's malfeasance gave him no choice.
You would agree that the plaintiff cannot have a double recovery?
Of course, Your Honor.
What he recovered from Hudson cannot be recovered again from these defendants.
Of course, and we tried hard.
And to the extent we may not know exactly what the recovery from Hudson was for, that would await further fact-finding in this case.
Of course, Your Honor. Although with the second settlement, we do know that all that Mr. Hudson is ever going to pay to Mr. Stone and his companies with respect to these transactions is $3.2 million. That has been paid, that was part of the record. So whatever ambiguity existed previously as how much Hudson would or would not pay, we now know with certainty. The only question that remains is how much of damages are obtainable or properly assessed against the legal malpractice defendants in this case. It is not the exact level of damages alleged against Mr. Hudson or the exact same legal theories, or for that matter, the exact same parties.
Can I ask you, they also made a claim about your not having adequately made the but-for allegation, which we know has to be an illegal malpractice cause of action. I wonder if you could address that.
It is replete in the complaint, but to the extent they missed it the first time, we supplemented and amplified the complaint with Mr. Stone's 3 affidavits. And in each one, he states that but for the malfeasance of Mr. Popple and his law firm, and but for the malfeasance of Mr. Williams and his law firm, he would not have suffered the damages alleged. Under settled law, that's all that's required. There is no reason to prove with any certainty the damages incurred as a result of that malfeasance. In fact, the law from this court is clear. Proof at this stage of the proceeding is not required. All that is required is a reasonable inference of ascertainable damages based upon the facts alleged. The facts alleged are, 1, that revenues were diverted. You can count that. Number 2, that fees were diverted. You can count that. That profits or the value of real estate was diverted. You can count that too. That is ascertainable in many commercial real estate cases all over the country, particularly in New York. At this stage, we can also ascertain the legal fees that Mr. Stone and his companies were forced to incur as a result of suing to recover on the damages assessed. Those legal fees were already incurred in the first and second Hudson litigations. There's an allegation in the complaint that Justice Edme notes, which says that we have specifically alleged that we were compelled by defendants' malfeasance to seek to recover our losses by commencing a lawsuit against Mr. Hudson. Not an easy guy to sue. Took us a long time.
If you could wrap it up, thank you, because the red light is on.
Please, the court, we respectfully request that Justice Edmead's decisions be affirmed in all
Thank you.
respects.
Thank you, Your Honors. To resume one of the lines of questioning we were touching upon earlier, if we could go back to page 181 of the record, paragraph 22 in particular, while I certainly appreciate that the claims as described in that paragraph are phrased somewhat differently, I would respectfully refer to the panel to pages 18 and 19 of our moving brief, which compares the relief sought in both the first and second Hudson action with the relief sought as alleged in the legal malpractice claim against my client. And the panel will see that they are the forms of recovery and the remedies sought are identical. In addition, on the same page, and I think this sort of illustrates the point which I'm attempting to get across clearly, paragraph 23, the first sentence says, "Shortly after Popple resigned, I entered into settlement discussions with Hudson to resolve some, but not all claims arising from Hudson's breach of the agreement." So again, I'm going back to that just to reiterate the point. This was a business dispute between Andrew Stone and his entities and Kareem Hudson and his entities. Mr. Stone elected not once but twice to sue only Mr. Hudson. That decision has an effect and a consequence when it comes to trying to continue to make Mr. Stone and his entities whole down the road in a separate litigation. In addition to the Bernstein matter that I referred to earlier, I do think the case, which is also cited in our moving brief, resource funding, which is a second department case, is very similar from a factual standpoint. In that instance, there was also...
But, you know, of course, there's the sentence after where you stopped reading. Critical to my willingness to enter into a settlement with Hudson was the preservation of all legal malpractice and other claims asserted against Popel in the instant action. And it seems that there could be no question that in the action against you, the plaintiff will not be able to recover that which has already been recovered from Hudson.
You're right, Your Honor. That's a segue really into the damages aspects of our argument, in that right now, because there is a complete absence of allegations in the First Amendment complaint going to what the Popple defendants allegedly caused to enter them to settle not once but twice. But at this point, as a result of the $3.2 million that Mr. Stone has acquired by virtue of the second settlement, the amount of damages or the components of damages that allegedly remain are so obscure, there's no way to connect them or to identify them clearly to anything that the Popple defendants did or did not do.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. I just want to make a few very quick points. One, just picking up on the question of the damages that we've been discussing. The counsel said that there was $3.2 million from the second settlement. In fact, as explained in the brief, there was far more in that second case than just a mere payment. There was, and some of it's under seal, so I want to be careful about it, there was an indication there was control of some company was apparently conveyed, and there's language that really suggests that there's additional payments, and there's some language about kind of resolution and non-interference with some other deals. So whatever it is, it's not kind of a simple, clean, it's this amount of money. There's a web and a jungle there of sorting things out if the case goes to that point. Past that, I also urge the court to look at the Stone affidavits and look at it carefully, because Mr. Stone does not say that he retained or he thought that Mr. Williams was doing all of this general representation. He's very specific. Paragraph 7 says that even in his subjective view, he was only looking for that he thought that to explore making acquisitions of church-owned properties that fit their investment profile. That's his own subjective description. That's from 2011. He then jumps and he really says the only thing that he claims Williams ever did was get involved in the Y-15 project, which was a $350 apartment unit project involving 31 buildings that happens in apparently 2014, 2015. So I think if you look very carefully what he looks at, what he says, even he subjectively thought Williams was doing, it's not what the plaintiffs are claiming in their briefs. It's a different retention, and I think the cases such as Dennenberg, where this court very carefully looks at, even subjectively, what someone says they're retaining the person for and what they are, what the claim is actually about. The claim here is about structuring those business deals, which he doesn't even say. Thank you. I realize I've pressed my time, Your Honors.
Okay. Thank you very much. Thank you all. Think Forward Financial versus On the Level.
Your Honors, may it please the Court, John Nutter appearing for the Del Shah entity appellants. Your Honors, this is a motion to dismiss respondent's breach of contract claim pursuant to CPLR 3211 on the ground that Real Property Law 442D bars the claim. Our position is that the admissions in the pleadings, the complaint and the amended complaint, establish that with respect to this transaction, real estate was the principal element, and the transfer of real estate was the dominant feature.
So what about this consulting agreement that the parties entered into?
Well, Your Honor, I think the case law is clear. You know, a party can describe the services however it wishes to in an agreement, but if it involves brokerage services and real property is the dominant feature of the underlying transaction.
I mean, I know that Judge Measley had a long oral argument on the record, and afterwards she said, look, I can't really figure out, again, a 3211 motion, all we have is the complaint and a few extra documents. What is the main feature? Is it a real estate feature under which would be controlled by the real property law, or is it really a consulting agreement? And, you know, is that the main feature? And I have a copy of the consulting agreement, and it does say the consultants have been retained to provide consulting services. So it's a funny arrangement, but it seems to have a little of both. So how do we figure out which is the main, and how do we, you know, so as you want us to completely throw out the case?
Well, I think you first look at the NDA, which is also in the record.
Yes,
and you find there that the parties specifically noted that respondents would enter into a fee agreement for introducing OTL to the project. So you know, from the outset, they identified what I would contend is a brokerage service, introducing, okay? And then the pleadings make clear that those introductions occurred.
But what about the aspect of promoting the bid, of trying to actually get the bid accepted? They seem to present sufficient evidence to demonstrate that that was the greater purpose here.
Yeah, they have some very vague allegations as to some emails that they exchanged with respect to this RFP. But I think when you look at the structure of the transaction, which required the transfer of the property, and the nature of the fee.
Well, counsel, the NDA might describe as a sale or a joint venture for development, but the consultant agreement says something else, right? Which would provide some sort of contradiction, saying that the plaintiffs were retained to provide consulting services in connection to a joint venture to redevelop. Is that supporting your argument or contrary?
I believe the consulting agreement supports our argument, Your Honor, for this reason, because it states that respondents are going to charge a consulting fee for facilitating the transaction. Now, we're talking about facilitating a transaction in which, again, the first step, the necessary first step.
But it's also putting this together, isn't it? You have got to bring in the original parties can't handle it, you have to bring in DELSA. So isn't there, and you're forming a new entity altogether, aren't those aspects of it not brokerage-type activities?
Well, what they're alleging they did, Your Honor, are brokerage activities. So formation of the entity was done by the sponsor and by the former property owner, right? What the respondents are alleging that they did is perform this, is perform this introduction, okay, and then charge a fee.
But part of this whole arrangement, you've got to go out and find an entity which is capable of pulling off a project of this magnitude, right? And that's not particularly real estate brokerage service, is it?
Well, I believe that's part of what the owner was doing when it sent out the RFP, was trying to find its development partner. I think when you look at the pleadings here, what the respondents were doing was performing brokerage services.
The real property law talks about the fees or commissions for the performance of services facilitating the sale of real property. But this was the developing of the whole process, so it's more than that. You know, maybe eventually you'll win, but I mean, at this point, I think it's sort of a hybrid.
Well, respectfully, Your Honor, and if you're, not comfortable with ruling on 3211 grounds, I would only say that I believe that 442D also applies to transfers, exchanges, and I think that's what we're dealing with here.
Thank you.
Thank you.
May it please the court. Martin Shaw, Lester Bleckner, and Shaw for appellant on the Level Enterprises. Picking up on what Mr. Nutter had indicated to the court, essentially that the transaction that was referred to began in approximately 2013. In fact, the deed, as well as the attendant documents for construction of the project, were finalized in 2018. It was only upon the transfer of the property and the collateralizing of the property with a construction loan in 2018 that the plaintiff respondents indicated that their fees, consulting fees we'll call it, were due and owing. In fact, the whole premise of their claim was that this was a real property transfer, that their fees would not be due and owing until the real property was transferred in 2018.
Well, weren't their fees based to some extent on the value of the land that was transferred?
Correct,
So
and
that's
that
why
really...
they possibly why they couldn't have collected fees earlier, because they had to wait for the whole transfer to take place, even if that wasn't the only service that they were providing.
And not quite, Your Honor. And with all due respect, there were certainly appraisals prior to that time. There were certainly offers of back and forth. So the whole
But the
premise
value
that...
doesn't come down till the value comes down.
Right, but the whole premise that this was a dominant real estate-based transaction and subject to RPL 442D was really based on the fact that there was a transfer of the property in 2018 pursuant to a deed. In addition, the property had to be collateralized for development purposes, had to be collateralized by construction loans, by mortgages, by guarantees, and so on, and that is indicated within the plaintiff's pleadings that, in fact, that was the trigger to the fees being essentially due and owing. If the fees would not be due and owing without the transfer of the real property. The fees would not be due and owing without that deed being filed, without ACRIS documents being filed, without the 26 million, et cetera, that was supposedly the value of the property, without a recording of the transfer taxes. In fact, the whole development could not have been accomplished without the condition precedent of the deed being transferred. Without the deed being transferred, this would not be a real property and real property transactions subject to 442D. And in fact, that's what it is. We could call it whatever we want to call it. That, in fact, this court has indicated in prior decisions that whether it's a management agreement or a consulting agreement or something else, if the dominant feature is real property and transfer of real property, then that dominant feature should indicate and does indicate that the person that brought about that transaction, the claim is not consulting, but it's a brokerage agreement. And as a brokerage agreement, 442D would be applicable and has to be complied with.
Thank you.
Thank you.
If it may please the court, Scott Waller from Hiller PC for the plaintiff's respondents.
So if this is not a brokerage agreement, why does the June 28th, 2013 agreement speak of compensation in terms of 2% of land price? Doesn't that connote a real estate deal?
No, Your Honor. The parties are free to calculate their fee in any way they wished, but the case law is clear that for 442...
Well, clearly you do, but when you calculate it in that way, that's how you would typically think that you're calculating a real estate brokerage commission.
You do, Your Honor.
2% of the value of the deal.
That's correct, Your Honor. But for the case law is clear that for 442D to apply, what the court must look at is what is the dominant feature of the transaction. And if the dominant feature of the transaction is not the transfer or sale of real estate, then it really doesn't matter how they calculated their consulting fee.
Is there a clear dominant feature here?
I think so, and if I may, I'll ask the court to turn to the supplemental record. First to supplemental record 3. This is the proposal that the defendants themselves prepared with my client's help and assistance and submitted to START, who owned the property, in response to START's RFP. Now, if you'll notice that it's entitled...
Even if you were, sorry to interrupt you, but sure. Even if you have a consulting agreement that's on the 2 pages before this plan, you have a consulting agreement, but it does seem that if there was not a real estate transfer, that the whole thing, the whole agreement would like be busted. It's almost like the legal malpractice argument, but for the transfer of the property, there wouldn't be any consulting. So does that make the transfer really the main part of it and the consulting only, a secondary?
No, Your Honor, the transfer of the property was a capital contribution, let's be clear. It was a capital contribution to a newly formed joint venture entity between the owner and developers, a typical structure for real estate development, okay? If you look at SR3, this is their proposal. They entitle it a joint venture proposal with the Addiction Research Treatment Corp., which is the former name of START, for the development of 22 Chapel Street, Brooklyn. The next page, in their introductory letter, they state that the proposal sets forth the defendant's proposed multi-use development of START's property. And then further down, it says that the defendants would work together to ensure an efficient execution of the proposed development. Later on, at SR 16, the defendants state that the property will be developed by the sponsor, and the sponsor is defined as a new special purpose entity that was created by the defendants, Del Shaw Capital and On the Level Enterprises, two of the developers. So you see, the defendants themselves had all along had characterized this as a development project. And if you go to the actual RFP itself, the RFP, which appears on the supplement, and I'll note to the court, by the way, that the defendants left out their own proposal from the record. We had to make a motion to supplement the record, even though it was attached to the complaint and referred to in the complaint. And you could see why once you see what their proposal provides. But if you look at SR 31, SR 31 is the actual proposal from start. Again, it's entitled, "A Request for Proposal for a Joint Venture Real Estate Development Project" at Start's address.
So
On the next page.
Counsel, not to interrupt your reading,
Sure.
I just want to know, in light of everything that you just said, where the NDA refers to it as a sale, how should we construe that?
Let's turn to that page, Your Honor. I'm glad you asked. The NDA appears at, I'm sorry,
124.
124. The full language of that provision that opposing counsel misquoted states, "The parties acknowledge that it may be necessary for disclosure to provide to recipients certain information considered to be confidential, valuable, and proprietary to disclosure for the purpose of enabling a recipient to evaluate a potential business relationship with START in connection with the sale or joint venture for the development of START's property." Okay, so it was always contemplated that this could be a joint venture for the development. And by the way, this NDA was entered into before START even issued its request for proposal. And it really has no bearing on what START actually wanted to do or what was planning to do. And as we just saw, START always was planning this to be a joint venture development project. Nowhere in their RFP do they suggest that they're seeking solicitations for an acquisition or a sale. That was never contemplated. And I'll just remind the court again that this is a 3211 motion based on the unrefuted documentary evidence. At best, from defendant's perspective, there's issues of fact, what the dominant feature of this transaction is. And also turn to the services that my clients provided, which is another reason why 442D doesn't apply here. My clients never were engaging in any real estate brokerage activities. They were preparing a proposal and advising them on the request for proposal process. And one more point, if I may, quickly, just to address a question that came up about the measuring the value of the services as a percentage of the land value. This court in Gerstein v. 532 Broad Hollow Road, and that's at 75 AD 2nd 292, rejected that very argument. In that case, a plaintiff who is not a real estate broker was hired by the defendant to provide services in connection with defendant's efforts to assign the lease to an office building and then later to sell the property.
Thank you, counsel. We know the case.
Thank you very much.
Very briefly, Your Honors. I believe the NDA here is key. It does refer to a sale in the recitals, but more importantly, it refers to what the respondents were envisioning charging for, introducing the parties. That's exactly what it says. That's in the pleadings, the allegations in the complaint. That's what respondents are alleging they did to be entitled to this fee. With respect to the issue of development and the RFP.
I mean, isn't that really just a portion of what they're asking for? They're also asking for consulting fees for their development of the whole project.
Again, Your Honor, there are some vague allegations about emails relating to the RFP. That's the only other reference to alleged services provided in the amended complaint. The introduction is a very clear allegation, I believe. That allegation is not vague and conclusory. With respect to the development issue, I mean, I would say again, none of the development would occur but for the transfer. It was critical. It was critical, and that's why it was necessary.
It seems from the more you make your argument that there certainly are questions of fact here, and not that this is summary judgment, it's just the opposite. And we've heard so much about the posture, but from the perspective of this case being one for the motion to dismiss the complaint, isn't there enough here?
Respectfully, Your Honor, I believe there's enough when you look at the nature of the services provided, the nature of the transaction, and what triggered the fee and why the fee is being charged.
Thank you.
Thank you, Your Honors.
Thank you, Your Honor. I'd just like to note that in terms of the 3211 motion, that the legal claim or the legal conclusion that there is not a 442D component here by the real estate really is not supported by the facts. And if it's not supported by the facts, then I believe that, with all due respect, Your Honors, that the motion, the 3211 motion should have been granted. This situation in terms of from 2013 to 2018 and to date was not in a vacuum. The plaintiffs' respondents indicate that this was a capital contribution. Well, if it was a capital contribution, then as a JV, that capital, the land, could have been inserted as part of the JV, but it was not. Instead, the land was transferred. It was sold. Everyone's admitting it was sold. The land was sold, and again, the claim for the consulting services, quote unquote, was based on the value of the transfer of the land.
As counsel said, the Gersten case suggests that there are instances, based on the facts, where that would be all right.
Except in this case, Your Honor, that the dominant factor here was the transfer of the land. And there's been no claim by plaintiffs' respondents as to any consulting services due or fees due for the construction loan or for any other aspect other than the transfer of the real property. That in and of itself, as this court has indicated, let's say in Kuchar, in that case, in Kuchar, there was a management fee, but the claim really was based on a transfer of real property. That's essentially what happened here. Over 5 years later, after this agreement was put into effect, the real property was transferred, and only at that point was the condition precedent met for the payment of those fees.
Thank you. Thank you all. Lopez versus Hallett Astoria.
Good afternoon, Your Honors. May it please the Court. Sean Harrington here on behalf of the Hallett's entities, the Durst Manager LLC, SRDA Manager, and New Line Structures, the defendants' appellants. With the Court's permission, I'd like to briefly address 3 points. First, I'd like to just quickly note that this case is a bit unusual procedurally. The Supreme Court denied defendant's summary judgment, and then upon searching the record, granted plaintiff summary judgment on his Labor Law Section 200 claim against New Line, and then Labor Law Section 241-6 claim against all defendants. I respectfully submit that this Court should grant summary judgment to defendants or, at the very least, deny plaintiff summary judgment.
On the 200 claim, could you address that? So New Line was the construction manager, right?
Yes, that's correct, Your Honor.
And so do you see, what happened here was the plaintiff was standing on top of a hoist and another hoist moved, and they try to tell them, don't move, stop, nobody heard them because allegedly they were wearing headphones listening to music, and it ultimately ended up with his foot getting amputated, I believe. It hit him up and hit him down, or the other way around. So what responsibility did your client as the construction manager have to coordinate the trades, and how do you, where does that fall on 200? Shouldn't there be, how do you get away from the judge finding that you're responsible under 200 for that?
Yes, Your Honor, thank you for bringing that up. Here, what plaintiff alleges and what the record shows is that New Line had a representative on site who, according to plaintiff, was responsible for coordinating the different trades at the site. However, I'd like to note that S&E Bridge had a contractual obligation to ensure proper coordination between the contractors at the site. Here, New Line did
How
not.
did they have the obligation if New Line was the construction manager?
Well, New Line, the record merely shows that New Line may have exercised general supervisory authority, such as the ability to stop unsafe work at the site.
So let me just be clear on what you're saying. So under the agreement, New Line was responsible for coordinating work between the subcontractors, including the means, methods, techniques, sequences, and procedures, and coordinating the safety programs, right? That's on record 576 through 578 and at record 580. So
Well,
in the context of those responsibilities, what were they supposed to do with regard to the hoist that day, for example, when two different trades or two different companies were coming in and dealing with the hoist? One's repairing the hoist, one's operating the hoist. Whose responsibility was it to direct the trades when they come in to the work site that day and they go off to the trades?
well, yeah, here there's no evidence
They
that
go off to their spots, rather.
Yes, Your Honor, thank you. So here there's no evidence that New Line actually directed plaintiff or the adjoining hoist operator. Here, the adjoining...
When you say direct, what do you mean?
Provided work-related instructions or directives.
So-
Otis of We Prevail had communicated with the plaintiff and Torero of S&E that day, hadn't they?
So yes, S&E Bridge employees communicated with the adjoining hoist operator to travel up additional floors within the work site.
So what is...
We Prevail, Otis's We Prevail and plaintiff supervisor are in contact that day, aren't they, as they're each on different hoists?
I'm sorry, Your Honor, would you mind?
Doesn't Otis of We Prevail, isn't he in contact with S&E's employees on the day of the accident?
Yes, that's correct.
So what is... okay, I just want you to finish the answer there. Yes, that's correct.
Yes,
Anything else?
S&E Bridge employees were able to communicate with Otis, the adjoining hoist operator, on the day of the accident.
So
they
with regard to
actually did,
New
didn't
Line, if I could just finish the question that I had before with regard to New Line, what was New Line's responsibility with regard to the different trades?
So
When they come in, what does New Line do or not do?
Yes, Your Honor. So New Line had general safety authority.
Tell me what that means, specifically with regard to when these trades come to the site.
So if they see something, they can stop unsafe work.
Something like what?
For example, if they had notice that plaintiff was going to perform work on the tower mast, they could coordinate and make
Well,
sure.
wouldn't they know why plaintiff was there, that they were coming to work on? Plaintiff wasn't working there all the time. Wouldn't they know why plaintiff's the company was there on site? Isn't that their responsibility to know why they're there?
Yes,
I mean,
Your
for
Honor.
example, if there's an HVAC unit that has to be installed or there are windows to be installed, New Line should know, oh, they're coming to install the HVAC unit. Oh, they're coming to install windows. Didn't they know that the company was coming to repair the hoist?
Yes, Your Honor. And,
Okay, so they knew that. So what about the hoist that was not being repaired? They know, I mean, they are responsible for what's going on the property every day. Do they not know that there are hoists running? And
Well,
who's running the hoist? I mean,
yes.
they wouldn't let the window people come to run the hoist, would they? They know that the people who are running the hoist are in there to do that. Is that right?
Yes, Your Honor. So
they know where both trades are.
That's correct, Your Honor. They knew that in general, they were extending the elevator track so that the external hoist can move up to additional floors.
So they know that somebody is working on one hoist and somebody else is running another hoist.
Yes, they have general knowledge of that for sure.
Okay, so what is their knowledge with regard to the safety issues? Because I thought that New Line was responsible for coordinating safety programs. Like, I guess, to make sure OSHA things are coordinated and appropriate. So what's their responsibility with coordinating safety programs? What does that mean?
Well, they had general authority to ensure that the worksite was safe.
You keep saying that, but I'm not quite sure that I'd like you to explain it in the context of this. Was it their responsibility to ensure that a trade wasn't working, one trade is working on fixing an elevator while another trade is running the other hoist rather, right next to it?
So the simultaneous operation of the hoist, and as plaintiff admits in his brief, was that happened. That happened at the work site. The issue was that New Line didn't have notice that on this particular project, no one had worked on the tower mast previously. They had no. They
didn't. I'm not asking you if they had specific knowledge of how it was run. In any case, were there other questions? Did you have further questions on that issue?
So when Otis, who's there for We Prevail, comes in that day, and plaintiff and Osiris are there from S&E, what do they do? How do they interact between them? Does the record reflect what their interaction is?
So plaintiff and his co-workers interacted with Otis to travel up the additional floors on the day of the accident. While they were, plaintiff and his supervisor were operating on the external hoist, plaintiff's supervisor went inside of the hoist to fix an issue. The proper protocol at that time would be if plaintiff or anyone else wanted to work on the tower mast, was for the plaintiff or anyone else to let the adjoining operator know.
How do they do that? I mean, he's just not sitting next to him. They have a telephone, they have what do they have?
So they can either communicate via radio or in person, and as the New Line accident report states.
It's your position, is it not, that Otis or, not Otis, that the plaintiff or Osiris should have told Otis that, look, we're going up on this hoist, watch out what you're doing from the outset before they started? Isn't that your position?
Yeah, it's our position that plaintiff, according to their custom and practice, he was supposed to let the adjoining hoist operator know to shut down the adjoining hoist before going onto the tower mast.
And with respect to what New Line's responsibility was from a safety perspective as the coordinator of the safety programs, it was perfectly okay for New Line to allow one trade, they're supposed to know where the trades are, to allow one trade to go and work on a hoist while the other trade is operating the hoist. That's okay. That's your position?
Yes, Your Honor.
Okay, thank you. Let's hear from the next person, because you can think about the answer if you want to answer further on rebuttal.
May it please the court, John Shaw for a plaintiff respondent. Just taking it one step further, when I was preparing for oral argument, I looked at Mr. Pollard's testimony again, and these two Q&As are quite glaring, putting aside that they were responsible
So
under the
Mr. Pollard
contract.
testified, did he not, that S&E trained Otis on the job, on what he was supposed to do? Not New Line, but S&E.
New Line was responsible for coordinating the trade.
But what did Mr. Pollard testify to as to who trained Otis from We Prevail?
There was testimony that Otis was an experienced operator who was an independent contractor separate in part from S&E, Your Honor.
But to the extent he got training, it came from S&E.
To the extent he got training at this job, but that, with all due respect, is irrelevant because New Line, which was on notice that there were two trades operating.
So at the record at page 266 to 267, doesn't Pollard testify that Otis was trained by S&E to operate the hoist, which consisted of maintenance, visual maintenance, checklist, and how to operate the equipment?
He was trained by S&E, but the coordination here is prevalent. In page 269, Mr. Pollard was asked, now, are there any rules with respect to operating two hoists at the same time? Answer, no. I mean, that was a violation of 6.3G. And going with respect to Otis, page 272, is there any procedure whereby Otis would contact the other car to see what was being done?
You're referring to the 241-6 cause of action.
But it also goes hand in hand with the 200 cause of action, because under the contract and under Mr. Pollard's own admission, they were responsible for coordinating the trades. They were responsible for making sure that the trades operated safely, and they were responsible for having a safety plan as per the contract, as per Mr. Dragone, the owner's testimony, and they admitted, is there any procedure whereby Otis would contact the other car to see what was being done as to whether or not it was okay for him to bring the car up or down? Answer, no. Page 272 of the record. They were on site, they were on notice of these two trades, and they knew very well that you should not be having two different trades operating a car simultaneously.
So on what basis do you say that they should have known, that they knew this, that it was their responsibility? You started to say something about page 269.
Under 241-6, regardless of notice, as Your Honor knows, they violated 6.3 G and 6.1C, and they admitted it was a materials hoist in their own brief on page 6.
I want you to direct your attention to 200 right now.
Absolutely. They were on site, number one.
What does it mean they were on site? And were they on site that they were at the place of the job which is being, did they have a person at the site of the two hoists as this job is being done? Is there someone watching from New Line as Otis is working? And
First of all, they were responsible for supervising the work and coordinating the trades.
That doesn't mean that they, I'm sorry, but with regard to the on-site, when the company is responsible for coordinating between the subcontractors and responsible for the procedures, the means, the methods, and the safety of the program, on-site doesn't mean that they have to be there to watch and instruct every trade specifically. They would have to be able to be in 5 places at once. What it means, and maybe you can clarify, because maybe I didn't state that right, is that they know where the trades will be. So for example, in this case, they know that there's a trade, one company, that's going to be fixing the hoists. They know that. They're on the site. They have to know why they're on the site. Is that right? And they know that another company is running the other hoist. My question is, would that be the responsibility? What does it mean on site?
Absolutely. In fact, Mr.
Absolutely, which one?
That they were responsible for making sure that one trade would not be operating the hoist while the other trade was there. Mr. Lopez testified that there was a representative from New Line right there when he went to go to the hoist that was taken up by Otis so he can repair the other.
When you say right there, what do you mean?
When he went, in his affidavit, when he went right up to go up on the hoist that was operated by Otis from We Prevail, there was a representative who he identified was a representative from New Line for the 1 month that he was on site, Mr. Lopez, and he was directly there.
So you're saying in this case, on site, with regard to New Line, the person was right at the hoist?
Correct. It wasn't some general knowledge. He passed by him right when he went into the hoist and was taken up by Otis. And they knew very well they had obligations. They knew there were supposed to be radios provided, but what was their testimony? Mr. Pollard said, I don't know if Otis had a radio. how do they, we have the radios, well, does S&E or We Prevail have access to those in the office? No, they do not. And he had no clue whether or not they even had a radio, which was the
And who was supposed to be giving the radios? Who's supposed to be
It
distributing?
was the obligation of New Line. That's why they had the radios. He admitted, Mr. Pollard, in his testimony that, well, they were supposed to have radios. We provided radios. Well, he admitted he didn't even know if Otis had a radio, and who at the time had headphones, which clearly the representative from New Line saw, and that's a no-no. And he admitted that, I don't know if Otis had a radio, and Mr. Pollard was on site that day, and he's there 6 days a week, 10 hours a day, and he admitted, I don't know if he had a radio, and they don't have access.
Can I ask you one unrelated question, because you don't get to come
Your
back
Honor.
up again? So we know that there is a motion that was made here to stay the trial pending the hearing of the appeal. So obviously you haven't had a trial, otherwise you wouldn't be here, up here now. There also was the judge below, I believe at the request of both the plaintiff and the third-party defendant, did sever the third-party action. Is that how it stands now? It's severed?
Correct, Your Honor.
You're planning to go to trial just against the defendants?
Correct, and then obviously at the conclusion of this trial, they can address the third-party claims. We moved and third-party defendant moved to sever because very briefly.
Well, because I know why.
Right,
I
right.
read why it was. I just wondered if, and that, I guess that's still your position to go with the just the main action.
Correct, Your Honor.
So on the Labor Law 200, Supreme Court granted you summary judgment of that course of action.
Yes, Your Honor. We asked the lower court to search the record, and certainly, which is nothing unique within their discretion, and in this court's discretion at times, they searched the record and granted our motion or our request on 200 common law negligence and 241 sub 6.
Okay.
Okay, thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. I'm Morgan Muller from London Fisher on behalf of the third-party defendant, respondent, S&E, Bridge and Scaffold. I'm here just with respect to the severance issue. It's our position that the court below properly exercised its discretion in granting the severance on the grounds that the third-party action, which was commenced over 2 years after the appellants received a bill of particulars, naming S&E as the plaintiff's employer, and 9 months after the note of issue was filed.
Which was several years ago already, right?
Yes. Yes. It's our position that discovery.
And you haven't been able to catch up yet?
No, the discovery is still outstanding. And it's our position that the delay to the action, the resolution of the main action, and the outstanding discovery owed to S&E was appropriate grounds for
What kind
severance.
of discovery is still outstanding that you couldn't have had for the past 2 years?
It's the
Deposition that you couldn't, well.
Yes, it's depositions. There's
But
also,
I mean, you had all these other depositions. We don't let people start all over with every single question. You just ask the things they haven't asked.
right, within reason, but we'd like to, just be entitled to our own questions and entitled to the own discovery that the.
You couldn't get that all done in these past couple of years.
No, we have not. If the court doesn't have any further
questions?
questions.
Thank you.
Thank you.
May it please the court. I just want to quickly address the labor law section 200 claim. It is our position that the simultaneous operation of the hoist was not in itself a dangerous condition. Plaintiff's labor law section 200 claim is based on a means and methods theory of liability, which means
Well,
that.
is it a dangerous condition when they're both operating simultaneously and one's being repaired?
So that was normal at the work site. What happened here was plaintiff decided to go onto the tower mast which made it a dangerous
Which
condition.
there was some
He
testimony that that was also a common practice.
But not with respect to this particular project, and notice was required. He was supposed to give the adjoining hoist operator notice before doing so. So here, plaintiff has to show that New Line exercised actual supervision and control. Plaintiff doesn't even attempt to do that. He cites the second department standard, which is that in the second department, you have to show mere authority to control the plaintiff's work. Here, he does not even cite to the correct standard. I'd like to quickly address the labor law section 241.6 claim. Both industrial code.
Also, you know, there's not even that there's a question of fact as to what occurred. It's that there's summary judgment on the cause of action against you, right?
I'm sorry, Your Honor.
There's summary judgment against you on the 200 cause of action, right?
Correct.
Not that there are any issues of fact.
Yes, Your Honor. Yeah.
So just to follow up on that, at minimum, you are asking for the question of fact or for summary judgment in your favor?
Well, we're asking for summary judgment in our favor, but
Based on everything that's been expounded today, wouldn't there at least be a question of fact?
well, respectfully, Your Honor, I don't think there's a question of fact as to whether New Line exercised actual supervision and control. They did not provide training to S&E Bridge employees, and they did not provide work-related instructions or directives to S&E Bridge employees. In fact, it was S&E Bridge that did all of that. Quickly, regarding plaintiff's labor law section 241.6 claim, both industrial code predicates solely apply to material hoists.
Thank you.
Okay. Thank you, Your Honor.
Thank you very much. Thank you all. FTF Lending versus Mavridis. Moyal, Pacman, etc.
Good afternoon, Your Honors. May it please the Court. I'm Gil Kugler of the law firm Fleischner Potash LLP, and I'm counsel for appellants Mavridis, Moyal, Pacman, and Sadkin LLP, and Matthew Weinberger, who was sued individually. This is a matter that addresses vicarious liability of an employee who was an associate of the law firm, the appellant law firm. I think that the key point that I identified in writing the briefs and in preparing for this oral argument was that vicarious liability is a strong concept that's.
But I'm sorry to interrupt you, but really, isn't he being sued here for his own negligence while performing legal services on behalf of the law firm, not necessarily vicarious liability? I mean, this is actually for his own negligent performance.
That's what the plaintiff, the respondent, has argued in this case. But when you look at, the reason I filed this as a 3211 motion is when you look at the facts that are alleged in the complaint, there are no facts that are alleged anything specific about Mr. Weinberger's actions, and what is alleged about Mr. Weinberger is that he was providing services to a client of the firm on behalf of the firm. There's nothing in this that, in the allegations of the complaint, that even allege, let alone establish, that he was acting outside of the scope of his employment. And that's where this strong public policy concept of vicarious liability comes in. Now, I'd like to point out also, there may have been, I hope it wasn't confusing in the briefing, but the application of, I'd like to address the application of Partnership Law Section 26.
Because I thought that said that a partner or an employee, the individual themselves, can be held liable on behalf of, for a wrongful act or misconduct committed when rendering professional services on behalf of the LLP or the firm.
Yes, okay, so I'd like to point out, first of all, that even the plaintiff, the respondent in this action, acknowledges that Section 26, the partnership law, Section 26, does not apply to associates. And I would just point the court to page 20 of the respondent's brief, where they state, as noted above, partnership law, Section 26, is not at issue, as Weinberger is not alleged to be a partner. And Weinberger is not alleged to be responsible for the wrong acts of the partnership.
He's not, but I don't think we're trying, I don't think they're trying to hold him responsible for any acts of the partnership. They're trying to keep him in at this stage for his own negligent acts in his behavior. I agree that he can't be held liable for the partnership acts, but it does not seem that that's what they're trying to keep him in for at this stage.
And the section says, maybe I'm wrong, but each partner, employee, or agent of an LLP. Doesn't he fall under the category of employee?
Well, let me just point out that the partnership law determines the liability of partners in an LLP. It does not determine the liability of employees and associates.
I thought that you really didn't contest that there's a sufficient allegation of negligence against Weinberger. Your point is that he's not responsible for what the law firm did, but that's true, but he is responsible for what he himself did.
That is not the case where he is working within the scope of his employment, and there's no allegation whatsoever or any facts to support that he did anything or engaged in any act that was not within the scope of his employment.
I mean, I don't think there's any allegations that he's acting outside the scope of his employment, but the Scarborough versus Napoli Kaiser Byrne case, I mean, that was also against associates, and the court, our court put the associates back into the case, saying that they could be responsible for their own negligence or wrongful acts. Doesn't say anything about that they have to be acting outside their scope of employment.
Well, the Scarborough case, it's appellant's position that that case should not have relied on partnership law section 26. And the reason that word employee is in section 26C1 is that there are some situations where an employee may be separately held liable, and that was actually what was dealt with in the Scarborough case. Those are situations where there are allegations of intentional misconduct that occurred during the conduct of judicial proceedings. You can't completely remove employees from that type of situation where there's some intentional misrepresentations or a pattern of misconduct.
Thank you. You have some rebuttal time.
Okay,
thank you. Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Tessa Scott, and I represent Respondent FTF.
Counsel, I just want to draw your attention to the complaint. Inside the complaint, Weinberger is mentioned once specifically. I think that's on page 30, on record 37, paragraph 4. But then every other instance where there's some kind of malpractice, it's referring to everyone specifically, or collectively rather, as defendants. Does there need to be more specific allegations as to Weinberger individually as to what he did, instead of just lumping him all together with the other defendants, the partnership itself?
No, Your Honor. In this case, the cause of action is legal malpractice, which is not subject to a heightened pleading standard, which appears in appellant-cited case Salazar. There, the cause of actions were grounded in fraud. Here, this is legal malpractice, and the legal malpractice is coming from the conduct of the associate attorney and the law firm, both of which have the same duty to FTF to conduct their responsibilities to FTF in a manner that is consistent with legal standards. So,
how do you read the Scarborough case? Counsel says it's with regard to really acts of serious misrepresentation or misconduct.
I'm sorry, could you restate that, Your Honor?
I said, how do you read the Scarborough case?
Of course. So Scarborough, contrary to appellant's position, pertains to both legal malpractice and also a claim pursuant to Section 487 of the judiciary. So yes, while there was a citation to intentional deceit, there's also an argument about the associates being responsible for legal malpractice. And in that regard, we have 2 partners and 3 associates that were brought back into the case on the causes of action of legal malpractice. The mere fact that there was also a claim for intentional deceit does not change the fact that the legal malpractice case was brought back in. Also, I want to address appellant's position with respect to respondeat superior. Realistically, respondeat superior does not stand to bar a plaintiff from bringing an action against the agent that or the employee that is alleged to have conducted themselves in a wrongful manner. The question, and in fact, there is New York State case law which states that if the employee is not part of the action, you cannot have a claim for respondeat superior or vicarious liability against the employer. And in this case, the decisional authority reflects that the employer and the employee can be brought into the same action for the same conduct, and there can be a recovery against both. And I just also wanted to note that contrary to appellant's position, there are numerous cases, including Spezio, which state that a law firm associate is not insulated or immunized from liability merely because of their employment at a law firm. Thank you.
Thank you.
Just to pick up on the one point regarding the Scarborough case, one of the critical arguments regarding that case is that the facts are distinguishable. And, this is a 3211 motion where the plaintiff has, or the charge of the court really is to determine only whether the facts as alleged fit within any cognizable legal theory. The Scarborough case involved an associate that intentionally misled the client regarding why the client's case got dismissed. And a partner later straightened that out with the client and told the client the truth. And therefore, the court in Scarborough left the associate in for the intentional misconduct, which was also part of the claim under Judiciary Law Section 487. Here in the case on appeal, there are no such allegations. There's barely an allegation regarding Weinberger at all, except in one paragraph, as the court has pointed out. And there certainly is no misconduct that would make that case, Scarborough, a case that the court should have decided, that the trial court should have decided this case on.
Anything
With
further?
that, unless there are any other questions.
Okay, thank you very much.
Thank you.
.644 East 14th Realty versus Mount Sinai.
May it please the court, my name is Kevin Fee. It's my privilege to represent Mount Sinai Health System. New York remains the financial capital of the world, in large part because New York courts consistently apply simple and straightforward rules to make commercial transactions predictable. 3 of those rules, in this case, warrant dismissal of the plaintiff's remaining claims.
Counsel, I'm sorry, just let me, there was a breakup fee here.
Yes.
Right? Why wasn't that an enforceable term with regard to the plaintiffs?
The complaint here pleads that the plaintiff did not, that neither side executed a lease. And the plain language of this agreement, which I'll read, said, should either party fail to execute a lease within 120 days of the execution date of this letter, that party shall pay.
Yeah, no, I think we all saw that, but the thing is, obviously, the breakup fee was if you didn't enter into the lease, so it anticipated that if the parties didn't enter into the lease, then there was this breakup fee. So of course we know they didn't enter into the lease, and that's why, you know, the letter of intent really wasn't an agreement. It was an agreement to agree. They didn't agree, but they put this breakup fee in there to cover that situation.
So in other words, wasn't the breakup fee just for that? We break up, we walk away, we go to our own sides.
The breakup fee lasted for 120 days. These parties continued to negotiate after the breakup fee fell away from the case, fell out of the agreement, and you were left with the language of the agreement, which said that the parties would not be liable without the execution of a further written agreement. And that is what controls this case, because after the 120-day period expired, that was the operative language.
You're saying that the breakup fee was subject to 120 days?
Yes, explicitly.
Where does it say that?
It said, as I was reading, should either party fail to execute a lease within 120 days.
That's the execution of the lease. We get that.
No. It's 120 days of the execution date of this letter of intent. That party shall pay a fee equal to $2 million to the other party as compensation. The letter of intent was signed by the second party on February 21st, I believe. The 120 days gets you to June 20th. So that is when the breakup fee period expires. In order to be entitled to a breakup fee, a party would have to sign the lease, a lease. A party is not entitled to $2 million if it failed to execute a lease.
But that's the whole point of a breakup fee, is that you broke up, that you didn't sign, sign.
Right, and neither party signed it, and a party who does not sign it is not entitled to a breakup fee.
But on March 12th, 2018,
correct,
you sent a draft lease.
And there was, on April 11th, there was another draft.
Right.
In May, there were 2 more. And on June
Counsel,
18th,
please, don't speak over.
I apologize.
Okay.
So a lease is sent to you, and you've got 120 days in which to sign that lease. If you don't sign it within the 120 days, then you owe the $2 million. Why isn't that the way to read it?
The way to read it is a party that does not sign a lease has no entitlement to a $2 million breakup fee. So if the June 18th lease that we sent to the other side, if we didn't sign it, we're not entitled to a $2 million breakup fee for them failing to sign it.
Explain to me, when would anybody be entitled to this breakup fee if not in this situation? Explain to me the scenario.
If we had sent the June 18th, 2018 draft lease and had signed it and sent it to them signed, we arguably would have a claim for a breakup fee if they failed to sign it by the end of the 120-day period. They didn't sign it. We didn't sign it. They didn't sign it. No one gets a breakup fee in that situation.
But you are sent the lease and you don't sign it, right?
Correct.
They send you a lease and you don't sign it. So aren't you the one who's not signing the lease?
No. You're not entitled to a $2 million breakup fee unless you have signed.
No, but wait a second. Leases are signed. I mean, the landlord sends a lease, the tenant reviews it, and then they sign it, and then the landlord signs it. That's how it happens.
What happens here, and it's pled in the complaint, is that there is a draft lease sent to us.
Right.
We gave comments on it. There is revisions to it. That's sent back to the landlord. The landlord has further revisions to it.
And eventually you don't sign it.
And eventually they don't sign it.
Well,
because
but you have to sign it first is what I'm
No,
saying.
it doesn't say that.
Well-
The agreement does not say that. The agreement talks about the entitlement to a $2 million breakup fee requires the other party to have signed
So
it.
in December, the plaintiff learns you're never going to sign the lease.
That's almost 6 months after the 120-day period has expired.
Right, but you have already not signed the lease within the 120-day period.
The 120-day period, when the 120-day period expired, the operative language of the agreement that applies is that neither side is liable without an executed agreement by both
I
sides.
mean, notwithstanding this breakup fee provision with the 120 days, plaintiff sends you a lease, you do nothing, they're not entitled to anything.
Neither side is entitled to anything if neither side signed the
Well,
lease.
we're looking at you, whether you owe anything. You're not suing them for the $2 million. So you do nothing, you get the proposed lease, you do nothing, you don't know
The complaint does not say we did nothing. The complaint says we sent back comments,
basically,
as did they.
let's say you did nothing.
Okay?
So notwithstanding the 120-day period calling for a $2 million breakup fee, you don't owe the money.
Not unless they have sent us a signed lease. The only thing remaining is the party who's being asked to pay $2 million has not signed the lease. Somebody has to sign a lease in order to be entitled to $2 million.
But where does it say that they have to sign the lease? Shall either party fail to execute a lease? If only one party doesn't sign, then they're liable, aren't they?
No, if a party hasn't signed, they're liable. There is the plaintiff concedes they did not sign a lease. They are liable for $2 million under the way you've articulated it, under the way I'm articulating it.
They're not refusing to sign they weren't the one refusing to sign the lease.
Well, the way the complaint is written, both sides refused to sign the lease. They in fact say in their complaint that their counsel expressly responded that, quote, it appears there are several discrepancies or inconsistencies between the lease and the LOI. So if you want to say someone refused to sign it, the complaint is saying that the plaintiff refused to sign it.
I understand the interpretation you're looking to place upon this provision. Question is whether it's a reasonable interpretation.
It is reasonable because a party is entitled to a $2 million breakup fee when they have sent the other party a signed lease and that other party fails to sign it. If neither party signs a lease, neither party is entitled to a breakup fee. I will reserve the rest of my time.
Thank you.
May it please the court, Noam Besden of Stein Adler Dabazelkowitz for respondent plaintiff 644 East 14th Realty LLC. I do not want to dwell on what was just discussed, just to say briefly, there is a counterclaim in this case. They are suing for the exact breakup fee that they're claiming requires this self-executed signature. So this notion that had on March 12th, my client sent a, for lack of a better term, self-signed, self-executed document, they would have been entitled, regardless of the comments that came back, to a breakup fee. But without the signature, there is no claim. It's just plainly disingenuous. They have that exact claim pending in this case. I'd like to move on to the promissory estoppel and fraudulent concealment claims, unless there are any other questions on the contract claim. Because the thrust of the papers that we got from Mount Sinai really just distorts what the fraudulent concealment and promissory estoppel claims are. And there's a lot of focus on this case, King Penguin, where this court affirmed Judge Masley, the same judge in this case. And I'd like to just read the language from that about what that case actually holds. I'm looking at King Penguin. I'll provide the site. It's 187 AD 3rd 688. I'm at page 689. And this is what that case says. It holds that where a term sheet requires satisfactory completion of due diligence and written execution of loan documents before the parties are bound, it's unreasonable as a matter of law for plaintiff to rely on the representations in the term sheet to proceed with the transaction. In other words, if a plaintiff is asserting fraud or promissory estoppel claims because they're saying they were justifiably relied on the terms of a term sheet that said that itself the term sheet wasn't binding, as a matter of law, you can't file those claims. Those aren't the claims that were brought here. We've said it again and again. Judge Masley made the same distinction. The fraudulent concealment and the promissory estoppel claims here are not premised on anything in the LOI. On the contrary, our argument here, if you look at our paragraphs 37 to 39 in our complaint, we describe, I'll remind everyone, this is a 3211 pre-answer motion. The paragraphs 37 to 39 describes a process whereby my client, at the direction of Mount Sinai, hired specific engineers, specific architects at our cost that we were directed to hire for the purpose of developing a building for Mount Sinai. Let's talk about how that came to be. The very premise of that entire deal is that in 2016, Mount Sinai announced, we're closing Beth Israel Hospital. We're going to take $85 million and invest in something called the Bernstein Pavilion. And in the context of that, they needed supplemental ancillary space to supplement the Bernstein Pavilion. That's where we stepped in. The building we were developing was to supplement the Bernstein Pavilion. The fraudulent concealment and promissory estoppel claim is that at some point, without telling us, they decided they were shutting the Bernstein Pavilion. Now we're developing as an ancillary supplement building for nothing. It was supplementing a building that no longer was going to be built. They didn't tell us that. So when they determined they weren't going to move forward, the breakup fee was triggered. We can get into what we just talked about, but the breakup fee was triggered. But they didn't tell us. Had they told us, I got news. We're not doing this Bernstein Pavilion deal. We're shutting it down. Your building is now either not happening or may not go forward. Then they would be subject to the breakup provision, and that would be our contract claim. But they didn't tell us.
Is there some place where it states that they were required to disclose that information to you?
Under the special facts doctrine, and actually pursuant to the case that Judge Masley did cite, which their appeal did not focus on in Madison Apparel, they have an obligation when they have peculiar or superior knowledge of a fact that we do not have, they have an obligation to disclose it. And that special facts doctrine, I can cite the cases on it.
Was that because, is the special knowledge that they were not going to ever enter into this agreement?
I think the special knowledge that we allege is they had special knowledge that the very premise of the deal we were doing had dissipated. So if I'm building you a building to supplement the Bernstein Pavilion, and you quietly decide there is no more Bernstein Pavilion, but you don't tell me, so I spend, and I don't have a time frame, I think we allege May to December 18, discovery will determine when they made this decision, but if there's a time frame where I am meeting, and we allege, and we did, weekly meetings with the architects you want that we're paying for, the engineers you want that we're paying for, staff, all of this to build a building.
So what duty do they have to you, and where does that duty come from? You're involved in a high-stakes, big-money real estate transaction and development. They have to tell you, hey, we're considering another possibility. I mean, don't you enter into this at your own risk?
Absolutely. There's a cause.
That's why you put the $2 million breakup fee into the agreement, it seems.
Two separate questions. I'm going to try and answer them as quickly as I can.
They complement each other.
Yeah, beautifully. The first question, now I'm going to forget them. The first question is the duty. The first answer is, it's not a matter of a duty. There's a cause of action called fraudulent concealment and promissory estoppel. They're elements. The only element they're alleging that we didn't meet, the only one is justifiable reliance. So the question isn't what duty they had. The question is, was it justifiable for me to rely on them? Now, they're not saying, I would say that's a fact question. They're saying it's not a fact question. As a matter of law, you can't have justifiable reliance. Why? Because of the LOI. But I'm not relying on the LOI. I'm not saying we have an LOI and we relied on it. I'm saying at some point you knew this building wasn't getting built, and we spent however many months and hundreds of thousands of dollars working on a building that was never coming to fruition.
Yeah, you have an LOI which says anyone's free to walk away if they feel like it without giving any reason.
Subject to a breakup provision. And again, I'll say it again, had they decided we're not doing the Bernstein Pavilion, we're not doing your deal, and they told us, then the breakup fee provision kicks in, they've withdrawn, subject to the breakup fee, and everyone goes on their way. The allegation, and I think Discovery has and will continue to bear this out, they didn't tell us. They spent time not, so again, the fraudulent concealment and the promissory estoppel claims are not that the term sheet made us rely on things. It's that the term sheet said, we're going to do a deal. They backed out. But they didn't tell us they backed out. So we spent months and money playing along with this, what I would call sort of charade.
Again, I say, so that's why you were smart enough, both of you, to put in a $2 million breakup fee in case this happened, because as Judge Friedman said, the agreement, the LOI did say that if anybody wanted to walk away, they could walk away. It doesn't say, I have to call you and tell you. It says I can walk away if I walk away.
Thank you, Judge Kabik, for reminding me the second question, which is...
I'll give you 15 seconds.
I'm going to do my best, which is simply that, again, it's not the same damages. It's not, the LOI says if you back out, there's a $2 million breakup fee. This is, you backed out. But then you kept us going for 6 months. The LOI doesn't cover that.
Thank you.
Thank you.
Justice Friedman, you identified it. On record page 140 is the language of the second LOI, and it says that we can withdraw without notice. Their argument is we should have given them notice that we were going to withdraw. We explicitly had the right to withdraw.
Is it the argument that you withdrew without notice, or that you withdrew and then kept going for several months without notice?
We were allowed to withdraw without notice at any time. And especially...
So you're saying that you're allowed to withdraw, sort of continue to lead them on so they could continue expending money as if this was going forward, when you full well knew all along that it was not going forward?
That we full well knew. That is not what's pled. This is not an instance where we entered into this letter of agreement, letter of intent, with no intent of going forward with it.
No, not at the time you entered it, but at some point in time, that's what happened. So you're saying that once that decision is made, that you're not going to go forward with this, you have no obligation to say anything, and you could continue along for months?
At some point in time, we are allowed to decide to withdraw from these negotiations.
Where is any obligation to tell them anything? You're in an adversarial relationship, and other than what you've agreed to in writing, which could end up costing you $2 million for whatever you've done, other than that, you don't have to tell them anything as you're negotiating this deal. You're negotiating against each other.
And that is what this court has said in Prestige Food. When the agreement says the party can withdraw, there cannot be any reasonable reliance as a matter of fact.
These are, after all, people who know that they're dealing with the real estate deal. Until they've got something signed which is binding, they have nothing.
Right. Now, so I'm going to move back to the breakup fee. And the key that you cannot ignore is the breakup fee had a 120-day time period.
So what about the fact that you counterclaimed, which is, I was trying to ask you that, but you avoided it, or maybe you didn't hear it. You are also suing for the breakup fee, so you think it's valid too.
They have said their legal theory is that and this is on page 22 of their opposition, that they are entitled to it because they performed their obligation to present a lease for signature. That's not what the letter of intent doesn't require either side to present a lease for signature. We could have presented the lease for signature and got the ball rolling. The bottom line is someone's got to sign a lease in order to get an entitlement.
But what's your basis of your counterclaim?
Because
you didn't sign it either.
If I'm wrong on this appeal and they're right that merely presenting a lease entitles you to $2 million, then we have a counterclaim for that because we presented a lease that they didn't sign. So we have to protect our rights going forward if that's what happens.
But in terms of the breakup fee, you're the one who walked away at the end because they learned that you signed a different deal, so they know you're not coming back. They didn't walk away. They walked away only because they know they're not getting your business.
In December of 2018, 6 months after the breakup fee provision had expired, we exercised our right to withdraw. The key thing here to remember is the withdrawal language, Your Honor, identified wouldn't apply in the first 120 days. Because in the first 120 days, we can't withdraw without paying them $2 million. But after the 120 days expires, if the parties haven't got a deal, if it hasn't gelled yet, we're reverting to the right to withdraw without notice provision in the letter of intent. So timing is everything.
So you waited to withdraw to try to subvert your obligation to pay the $2 million breakup fee and all the money they expended, not knowing that you were going to withdraw.
Most respectfully, as described in the complaint, the parties were negotiating this thing for months, and the deal fell apart at the end. But what is key here is their entitlement, either party's entitlement to the breakup fee had a 120-day clock on it. And we went long after that, another 120 days or more, when the parties tried to consummate a deal and didn't. They're
Thank
two
you.
different things. Thank you.
Thank you both. Timeliness versus Dorian's Restaurant.
Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. We submit that based on the court's conclusion that the plaintiff's proof established that defendant's cause that created the condition which resulted in the plaintiff's injuries, the court should have then determined that plaintiff made out a prima facie of negligence against the defendants, thereby shifting the burden to raise an issue of fact onto the defendants. Instead, the court concluded that summary judgment in favor of the plaintiff on liability was not appropriate because plaintiff's proof did not satisfy the standard under the res ipsa doctrine. We would submit that was error for several reasons. First, the plaintiff did not move under the res ipsa doctrine, nor is there's no legal argument raised in the plaintiff's motion that she was entitled to summary judgment under res ipsa. Plaintiff did not allege in her bill of particulars a res ipsa theory of liability. And as well, if plaintiff was moving under res ipsa, she would not have submitted an expert engineering affidavit to support her motion. It would not be necessary.
But does the expert engineering affidavit support a basis for summary judgment here, where there are issues with regard to whether there was a screw, whether there wasn't a screw, how it was truly affixed?
We would submit, Your Honor, that the Silberman engineering affidavit did support and sufficiently warranted summary judgment in the plaintiff's favor. And frankly, the court found that the proof was sufficient to show that the defendant caused the condition, taking into account Mr. Silberman's affidavit, as well as the deposition testimony of the parties, whereby Mr. Silberman concluded that it was the manner in which this plywood board was installed on the night of the incident constituted a defective condition because it was held together with a wood screw fastener.
But by the time he went to investigate it, there was a different hatch or latch on there. So he just looked at the pictures as to what happened, and the defendants, had some. Even if you made out your prima facie case on liability, the defendant said, "Well, our restaurants on 2nd Avenue for years and years, they were all kinds of construction going on right outside because of the 2nd Avenue subway, which I know that there was, and we all know that there was, and that helped, may have loosened it, and we really weren't aware that it was going to come off and fall. It never happened before." Isn't that at least a defense to, even if you've made out your prima facie case?
We would submit, Your Honor, that the proof that was submitted to support that argument that the 2nd Avenue subway somehow contributed to this plywood board falling off the wall was nothing more than speculation. You have the affidavit of Daniel Dorian, who, again, this was not raised during his deposition, I should point out, in terms of what, he was asked, the reasons he thought that the plywood board fell. He did not bring up the 2nd Avenue subway. This only came a year or two later in opposition to the summary judgment motion. We would submit it's nothing more than speculation. There's no evidence here that this construction was taking place the day of, the day before, 2 weeks before. There's nothing to show that any particular, demolition or construction explosions contributed to this board falling off. Instead, the defendant submitted some links to some YouTube videos for some news broadcasts, which took place, and these were from 8 to 10 months before the incident occurred. We would submit as too far in time to raise an issue of fact, to conclusively raise an issue of fact here to rebut the prima facie showing of the plaintiff. Particularly here where the court did not conclude that the defendants raised an issue of fact. The court concluded that somehow the plaintiff's proof, although establishing that there was a dangerous condition which the defendant created, somehow went off on this tangent about res ipsa, which frankly had nothing to do with the motion. Unless the court has any other questions, I'll reserve my time for rebuttal.
Okay.
Thank you.
Thank you.
May it please the court, my name is Nicholas Herzler. I represent 8 Tots responded in this appeal, Your Honors. First, we have a threshold issue of timeliness, which we submit that, it's undisputed this motion was 4 days late. It is true that, unfortunately, it is a tragic circumstance of the passing of Mr. Epstein.
And the court has discretion here, so why don't you move on to the next point?
Your Honors, I would submit the best I can say for plaintiff's theory here is that it's possible that the screw was taken in and out so many times that the wood deteriorated underneath, as the expert submits. However, there was no deposition testimony questions about that. There were no photographs taken of the plywood showing deteriorated wood. There was no detail elicited during the course of discovery to support the theory of the plaintiff's expert, who based his opinion largely on a single, very blurry, very dark photograph that doesn't show much of anything, and an inspection that occurred 3 years after the accident. And so it's possible, his theory, and by the way, I represent 8 Tots, the landlord. They occasionally had a vendor go in there for a reason to take the screw in and out. There's no showing that even if their theory is true, which it wasn't proven as a matter of law, but even if it is possible, that it was my client as opposed to the tenant bar in possession of the premises who actually created, as they allege, a dangerous condition. And so there's too many questions of fact here. I would also point out the affidavit of Mr. Dorian is admissible, contrary to plaintiff's argument. It was not contradictory of his deposition testimony. Again, the deposition was sparse. He was only asked about whether he conducted an investigation. He was not asked about other alternative possibilities. He was not asked about the Second Avenue subway issue. So I just don't see how the affidavit can plausibly be described as contradictory of his deposition testimony for purposes of the feigned issue rule. Oh, and I would also point out, there's quite a few phrases in Mr. Silberman's affidavit that clearly show his opinion is very equivocal under the case law and not without sufficient certainty to carry the plaintiff's burden of proof on summary judgment. I'm reading from the record at 283, appendix, at 283-4. He says it's also possible to strip the wood. He said the threads can tear out the wood. The panel could fall. This method to secure the panel was potentially improper. Even the plaintiff's own expert is unsure as to whether this is necessarily the case of what happened. And so we submit that, especially viewing the evidence in the light most favorable to the defendants as the non-moving parties, the order should be affirmed. Unless there are any questions, I'll rest on my brief.
Thank you.
May it please the court. My name is Andre Cargill, attorney for the defendant respondent, Dorian's Restaurant and Bar. Your Honor, the court properly denied plaintiff's motion in the lower court. Defendants have established a non-negligent explanation. We submitted an affidavit by James Dorian, which confirmed that the hatch had never fallen to his knowledge prior to the accident. Additionally, we submitted links and provided evidence that there were reports of an explosion at the Second Avenue subway construction site.
That's the Second Avenue construction subway site defense. But the question is that speculation? Is there any evidence that that would have been the cause of this other issue?
Your Honor, it is our position that it's not speculation. James Dorian said he believed that it could have been the reason why the hatch fell.
Was after this Second Avenue explosion, was there some inspections that were done that would support that theory? Or is it just, well, there was this explosion, let's point it in that direction? Why isn't that speculative?
To our understanding, we're not aware if there was an inspection that was conducted after the explosion. But with the explosion, Mr. Dorian stated that it potentially could have came loose, and it's not necessarily speculative because...
It potentially could have, but it could have potentially not have, right?
Correct.
Did Mr. Dorian experience the windows breaking, shattering at the time of the explosion?
Yes.
Did he experience the other things that he identified in his affidavit?
Yes. Which all established that it could have been from the construction explosion. Also, it is our position that plaintiff's expert opinion is conclusory and speculative. As you guys have noted, the inspection was conducted 3 years after the accident, and the expert compared his inspection with a photograph. That is purely speculative. Also, the expert mischaracterizes deposition testimony. Mr. Dorian testified that the panel had been removed sometime in the entire 15-year period. However, Mr. Silberman asserted simply that and assumed that the wood panel was removed and installed often, thus concluding that the wood deteriorated, causing the panel to fall. That is a conclusory and speculative opinion and should not be considered. We request that this court affirm the lower court's decision denying plaintiff's motion for summary judgment. That's all.
Thank you.
Just very briefly, in connection with the Daniel Dorian affidavit, we submit that even if it's not feigned, again, it's conclusory and based on speculation, and contrary to counsel's assertion, there's no evidence in this record that the premises sustained any damage as a result of the Second Avenue construction.
Well, the premises definitely sustained damage. He says he saw for himself the explosion happened, the windows broke. So maybe, I don't know about the piece that fell, whether it was damaged, but he definitely saw and experienced and witnessed the damage that he claims.
Right, but there's no evidence when that took place, vis-a-vis when the incident occurred. And then just finally, with respect to the Silberman affidavit, we would submit that there's a proper foundation for his opinions. It's based on his review of the photos, his personal inspection, his review of the party's deposition. And again, I just wanted to stress that the motion court did find that the plaintiff's proof, including the Silberman affidavit, made out a prima facie case that the defendants caused and or created this dangerous condition on the night of the incident. So we would submit that it's sufficient, and unless the court has any further questions, I'll rest on the arguments in our brief.
Thank you.
Thank you.
Thank you all. People versus Alexandro Ruiz. You may begin.
Good afternoon, Your Honors. Molly Schindler on behalf of Alejandro Ruiz. May it please the court. Mr. Ruiz's rehabilitation during his 12-year prison sentence is so exceptional and presents such a stark contrast from his prior conduct that a downward departure to SORA Level 2 is warranted. Mr. Ruiz committed this offense when he was just 22 years old. At that time, he had already accrued a criminal record and had already been to state prison for 2 years. But in that previous sentence, he had refused all programming, completely declining to rehabilitate.
How do we weigh the crime that was committed here in light of that? I mean, that's what we're really talking about here, right?
Yes, Your Honor. As part of the third step of the downward departure analysis, the court weighs all of the circumstances in the case, including the nature of the offense itself, which is certainly a factor. However, the legislature determined that that is not the sole factor. And in fact, they determined that a SORA proceeding should occur not at sentencing, when you only know what the defendant's criminal history is and what the instant offense was, but rather at the time they're being released to the community. Because what the person does and having that opportunity to see if they are someone who can rehabilitate themselves is important, and what the legislature recognized in that. And that's exactly the advantage that Mr. Ruiz took in his 12-year prison sentence in this case, unlike in his 2-year prison sentence when he was just a teenager. Rather than refusing programming, he embraced every opportunity that he had. I'll name just a few of them. He served on the inmate grievance community. That's a volunteer position just to serve his peers. He served as a law librarian. He not only did his own vocational programming for his own job prospects, he was then named as an inmate program aide so that he could serve others and train others in those same roles. He excelled in college classes. He earned nearly a 4.0. This is someone who dropped out of high school, and yet in prison in this term, he excelled in those classes, and his evaluators noted that he was a consistent voice of reason and maturity. He had high levels of intellectual curiosity.
So this is all admirable, but what we have to do is determine whether or not a downward departure is required under where the circumstances are of a kind or degree. I don't know that there are mitigating circumstances here of a kind or to a degree. He did very well, but that's the hope, that people do very well. I don't know that that is, exceptional in that way. There were still, what do you call, infractions, level 3 infractions. And so the question is whether or not those circumstances were adequately taken into consideration. And it seems like they were, because he didn't get points for everything. So,
Your Honor, what that factor, I think you're referring specifically to factor 13, which addresses somebody's conduct while confined. Right. What that assesses is it scores 0 points if your conduct was not unsatisfactory. So actually, and unlike Your Honor just stated that we would hope everyone does very well, that standard is actually a lot lower than very well. That standard is not unsatisfactory. It's mediocre at best. It means you haven't done horribly.
How many points, what's the points for level 2?
He was, the threshold is 105 and 110. That's the dividing line.
So he was like 35 points above the level 2, even with the no points under 13, which I understand you say doesn't necessarily recognize what he did. It recognized that he didn't do anything bad. But I mean, we know that the cases say that we only grant a departure or it can only go up and down, a departure, if it's an extraordinary circumstance. And the court did have a long SORA hearing, and I read through it, and I read through his decision, and he found that notwithstanding, the claims that the act was heinous and that the victims would spend their whole lives being damaged and as haunted for the rest of their lives. And he noted all of the problems, and yet he weighed it as a judge in Supreme Criminal, and he found that this was not the case that met exceptional circumstances. So why should we overturn the hearing of the judge that sat through all this testimony?
Your Honor, this court, the SORA court made 2 fundamental errors in its decision, and this is on page 12 of the hearing transcript. If I could just explain to finish quickly. The court first held that any conduct while incarcerated, no matter how exceptional or positive, is taken into account by factor 13, which is not at all, in fact, the opposite of what this court held in Williams, what the Second Department has held as well. There is conduct that is so exceptional that it's not captured by that factor. So that was a legal error that in and of itself merits correction. The second error the SORA court made is it held that Mr. Ruiz's prior conduct when he was in prison had failed to predict his conduct when he came out. That's the opposite of what's true. Mr. Ruiz, as I stated before, refused all programming, and it's not surprising that he then came out and did, recidivated or committed the instant offense. Whereas this time, the contrast between what he did in the last 12 years is so stark and so extreme that it really does present those exceptional circumstances that this court has recognized do exist.
When did the level 3 infraction take place?
He has had no infractions for 5 years before the SORA hearing.
But it wasn't 12 years ago. It wasn't when he first got there.
That's correct. But I would just also, whether or not the court finds legal error, we would ask it to substitute its own discretion for that of the SORA court. Thank you.
Good afternoon, Your Honors, and may it please the court. Emily Galt for the people.
Defendant was properly adjudicated as a level 3 sex offender, and the totality of circumstances do not warrant a downward departure.
So what about all of these extra, the extra involvement that count, positive extra involvement that the defendant took in prison?
Defendant
to
definitely
improve
made
himself?
strides towards rehabilitation in prison. We are acknowledging that, but the aggravating factors here, there are so many of them, and this court has to balance the aggravating versus the mitigating factors. Defendant blindfolded, tied up, and raped his victim at gunpoint. He was also in possession of a knife. He robbed and tied up other victims in the apartment. He told, when he entered the apartment, he said he was a police officer. His prior criminal record as well. These are all aggravating factors that outweigh the mitigating factors. His conduct in prison has been commendable, but again, these aggravating factors outweigh the mitigating factors. He was 25 points over.
But we know the aggravating factors that you're talking about, they're all taken into consideration. They're there. He did 12 years for it. But those already existed. That is the case. These things, they're saying, are extraordinary circumstances of a kind or to a degree that weren't adequately taken into consideration. Those things that were above and beyond what the usual defendant does in prison. So what kind of consideration should we give to those things? Have they or have they not been adequately taken into consideration? I don't think the test is to balance it against the aggravating circumstances, which in this instance are already taken into consideration. I don't think you asked for an upward departure because there were aggravating circumstances that weren't adequately taken into consideration.
Well, Your Honor, some of the aggravating factors weren't accounted for by the risk assessment instrument. For example, he did have 2 weapons, and he was only accounted for one.
You didn't ask for an upward departure, did you?
No, we did not.
So that wasn't before the court. The only thing before the court right now is a downward departure because of what they are saying is extraordinary behavior.
Right. Well, SOAR looks at 2 specific things, the risk of the offender reoffending and the harm that would be caused if the offender were to reoffend. And we would argue here that he has shown that he is capable of committing crimes with severe violence, and he is a dangerous...
You mentioned the prior record. He has 3 prior felonies. Is this one of the 3?
He was adjudicated as a youthful offender for a first-degree robbery. He had a 3rd-degree criminal possession of a loaded firearm. He had a 3rd-degree assault, which was a misdemeanor, this case, and then it was another 3rd-degree robbery charge.
And some of these crimes were committed while he was on probation or parole?
Yes, Your Honor. So they were all committed within a short time from either being on parole or released from parole. So this defendant, although he was released, he did all these things in prison and was released after 11 or 12 years. He's only been out for a year and a half, and that's not enough time. He's able to petition the court if he remains at liberty and lives a law-abiding life. He can re-petition the court at that time and ask for re-adjudication to level 2. But at this time, his past behavior just doesn't show that he can live a law-abiding life. And yes, these efforts in prison, we commend them, and we hope that he keeps making those strides towards rehabilitation while he's at liberty in the community. But until then, we ask that you affirm the level 3 adjudication. And if you have no questions at this time, we ask that you affirm.
Thank you.
Thank you. Your Honors, Mr. Ruiz's extremely positive accomplishments in the past 2 years that he's been out of prison are actually not before this court at all, and we would certainly be interested in bringing a modification petition. However, what the Court of Appeals has held is that that's not a substitute for an adequate downward departure consideration at the original SOAR hearing. And for the reasons that I've explained before, the SOAR court did not give adequate and correct consideration of his downward departure application. A level 3 is not only overstates his current danger to the community, but it also is unnecessary in light of the fact that he's on specialized supervision for the rest of his life. A level 3 adjudication in his case means that he has to check in with the registration office every 90 days. That requirement is relatively superfluous in light of the much greater requirements that he has on parole. And it's simply not accurate to classify him as being in the same position that he was at the time that he was sentenced on this case. There is no doubt at that time, if it were If a SOAR adjudication did take place at the time of sentencing, he would have been a level 3, but that is not the end of the inquiry. And he has truly shown an extraordinary transformation comparing his conduct, his life circumstances, his priorities. From then to now, everything has changed, and that was sufficient evidence for the court to grant a downward departure, and we ask your honors to do the same.
Thank you.
Thank you.
Thank you both. Caso versus Urban Builders.
Good afternoon, Your Honors. I am Afafe Suleiman from Kiernan Treeback, representing defendant, third-party plaintiff, second third-party plaintiff, Urban Builders Group. In this action, in this appeal, we respectfully submit that the lower court there were two separate decisions, the September 11, 2020 decision, which granted plaintiffs partial summary judgment on 240 cause of action, and then the October 6, 2020 separate decision, which granted Urban Builders summary judgment on the 200, 241-6, but denied that branch of the motion seeking.
I mean, your primary interest, I'm sure, is going after the summary judgment on the label or 241.
Yes.
What safety device, if any, was provided to the plaintiff?
Okay. The first point that we argue is that that question doesn't even come into the sphere of argument because the lower court erred in finding that under Rokovich, Robinson, and Blake, the decisions hold that the special hazards do not encompass any and all perils that may be connected in some tangential way with the effects of gravity. And in this case, the lower court relied upon Alonzo, which we believe is distinguishable. In that case, the individual worker fell through an unprotected floor, which he was not aware. In this case, Mr. Caso was not clueless.
So he falls through a hole in the roof, right?
Well, the work was renovation.
It's true he's removing the skylight, creating the hole, but he does fall through a hole in the roof. And
it's a flat.
Shouldn't something have been done to protect against his falling through that hole?
Well,
I mean, you'll tell me, well, he knows about it, he should have been more careful, but comparative negligence is not a defense for 241.
We also say that it was not actual gravity-related work. The gravity-related work, they were on a flat roof, they were able to walk around on the roof.
He fell through, the work doesn't have to be gravity-related. The accident has to be gravity-related. And in this case, he fell through the hole. So did he have a safety device? Was he given a harness to prevent that from happening? He was removing something from a hole. I think he fell through a different hole. But was there a third person there, for example, to say, no, put something in front of it when they lifted that, or to tell him, step to the side, don't go forward? Was there anything of that nature?
Yes, Your Honor. His foreman that day, there was conflicting testimony. Mr. Caso did testify on January of 2015 and again in June 2018. And he did state that he recognized that this was a skylight cover. He had worked on with this company for between 95 and 2012.
Didn't he fall through a different hole, not the skylight cover?
No, it was a
Oh,
skylight
he fell through
cover
the same
hole.
skylight cover hole? I
He was
wasn't sure if there was
instructed by
another.
his foreman to remove the skylight cover in order to continue the renovation work on the roof.
Right, but he fell through it.
And was specifically told to move it to the side. That was...
So his supervisor, Jacinto, tells him that. That's
Yes.
true. But isn't it something that you can recognize that as you're moving that skylight out of that and creating the hole, and he's carrying, and the skylight is being carried out of around on the roof, that there is a danger of falling through that hole, and shouldn't something have been done to provide him with protection against that?
I think the instruction to move to the side, coupled with his 8 years of experience doing roof renovation work, recognizing skylight cover, testifying that he knew what it was, and that he had worked on old buildings with old skylight covers previously, together make him essentially fail. He had failed to follow the instructions. Now,
Thank you. You can follow up with rebuttal. Okay, thank you.
May it please the court, John Shore for plaintiff respondent. I'll be very brief.
Does the fact that he falls through the very hole which he's just created change anything?
Not at all, Your Honor.
Well, wasn't he supposed to be working on the hole?
He was supposed to remove a cover.
So that they could
The
do something with
skylight,
the hole.
Right. He was not aware or given any protection that there was anything underneath, and they're misstating the record about, first of all, him being aware. Number one, he said he didn't know what was underneath, and then he testified.
Couldn't see through the glass. The glass
he
was
couldn't see
greenish
through
in
the
color.
glass. So, and their whole argument, besides their fallacious argument that it was not gravity related, he fell 13 feet onto the next floor, fractured his hip.
So we know he fell through the hole. Counsel says that he didn't pay attention. He wasn't listening because he was supposed to be going sideways. Instead, he went forward.
With all due respect, that's absolutely ludicrous. All that he was told was move it to the side. So first of all, it wasn't a warning, and let's hypothetically take it one step further and say Jacinto told him, which he did not, you better move it to the side, Manuel, because it would be dangerous because there's an unprotected covering underneath and no netting, and you weren't given any lifeline or protection. Under this department's law in Hill and the recent case of Meyer-Keene, a warning to avoid an unsafe practice does not constitute a safety device. Here, there was certainly no warning, and moreover, he was not given any safety devices, which was a violation of the labor law. He wasn't even negligent, and arguendo, if he was comparatively negligent, if you believe moving sideways means anything, that's irrelevant and not a defense to 240-1, as Your Honors know. If there are any other questions, I'll rest on my brief.
Thank you.
Thank you.
Contrary to plaintiff respondent's claim, there is case law.
Well, counsel, before you get to that, this department has held where there is a fall through a skylight by a worker, and there's been no safety device provided, that is, that does establish prima facie 240-1. Why should we deviate from that now, where there's been a fall through a skylight with no apparent safety device provided?
Even if the case is one contemplated under 241, the plaintiff must still establish that there was a violation, even if there's a violation, that the violation caused his injuries, caused his accident. Here, arguably, the failure to heed the warnings, and we argue that at least there's a question of fact.
There's a question of fact as to whether there was a netting underneath the hole, or whether he was given a lifeline,
Question of fact.
or whether there was a third person there to
There's a
say, don't walk this way or that.
Well, the plaintiffs argue that the instruction to move to the side is not a warning or
But
a
just let me
safety device.
make clear something. Was there a lifeline? Yes or no?
There's no testimony that there was, but there was also
Was there
no
netting?
testimony
Was
that,
there netting? Was there netting?
not that we're aware of, Your Honor.
Was there a third person up there to say, don't move that way?
The supervisor who instructed him to.
Who was working with him?
Yes.
So was there a safety device? What was the safety device?
Well, arguably the instruction itself and the knowledge that, that he had, the experience he had in his own testimony, that he recognized this to be a skylight cover, which impliedly covers a skylight hole.
Thank you. People versus George Garcia.
Good afternoon. Catherine Skolnick for Appellant George Garcia. Mr. Garcia, a nearly 70-year-old man with no criminal history, significant community ties, including a young son, and several grave health conditions, presents exceptional equities and should not go back to prison to serve the remaining year of his sentence. There are several paths that this court can take to accomplish that result. First, the court can reduce his sentence in the interest of justice, and it should.
But isn't there a mandatory minimum here? I mean, isn't there the minimum for the statute? Isn't it 3.5 years?
It is. However, this court has the authority to reduce the sentence. It did so in People versus Moore, where time served in that case was effectively less than the minimum. But even if this court finds that it can't do this within its interest of justice jurisdiction, it can find that further punishment would be cruel and unusual as applied here. And there's certainly plenty of precedent for...
But aren't there other people in prison right now with health conditions? Difficult, challenging health conditions?
Well, I don't think the comparison is to others in prison. The situation as was presented here...
Well, my point is that can be taken care of properly, health conditions that can be addressed so that the defendant is not under cruel and unusual circumstances as you posed it.
Well, our claim is not simply one of deliberate indifference, it's also proportionality. So it is a cruel and unusual punishment claim akin to others that this court has reviewed, such as one in which it found that in the context of a first-degree criminal possession of a controlled substance offense, it found that a reduction to a below minimum sentence was called for that particular individual. There's another case out of, I believe, the Second Department where there was a reduction given someone's lack of criminal record, age, poor health, and family circumstances. And our argument here is that Mr. Garcia falls into that category of people who really presents, exceptional equities. This crime is a true aberration, as several judges recognized in their decisions, and Mr. Garcia himself expressed his deep regret for his terrible mistake. He has complied with all court conditions at all points throughout the case, including during his stay. As I mentioned, he has several serious health problems, including experiencing cardiac arrest in 2019 while incarcerated. We do argue that COVID, the ongoing pandemic, presents a heightened risk for him, but as I said, the issue is also that the prison is not necessarily situated to meet his exceptional health needs. He has tons of family and community support. He had a long work history until he became disabled. He ran auto shops after leaving Cuba as a child, going to college, and playing professional baseball. He has a long volunteer history as well. He was a volunteer firefighter, and he raised money as a cyclist for hospitals and children with cancer. He's already served 2 years, and at this point, that was ample punishment to deter him from further conduct and to serve retributive ends. At this point, there's simply no purpose served in sending him back to prison to serve a relatively short period of time. But it does present an extreme risk to him, and as Judge Convisor noted below, could effectively turn into a death sentence. And this is not proportional, and that is the crux of our argument here. Under the Brody factors, he was an accidental offender, and this fits within the rare case exception where a sentence in the lawful range can be unconstitutional. And so for that reason, we're asking the court to reduce the sentence. Alternatively, it can find that a new trial is warranted for the reasons discussed in our brief as to what happened during voir dire. If the court has no further questions, then we would ask that the sentence be reduced or the conviction reversed and a new trial ordered. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Samuel Goldfein on behalf of the people. Defendant was caught red-handed with a loaded gun on a New York City street, and his intent to use it unlawfully was unquestionable. He got the minimum sentence for that crime, 3.5 years. That's the minimum term. It's required by law. I don't think this court has ever reduced a sentence below the minimum. This Moore case, defendant was incarcerated on February 21st, 2019. This court reduced his sentence to time served on March 4th, 2021. That's 2 years and 11 days later. He was released the following day, 2 years and 12 days later. That's more than the 2-year minimum term. Defendant should serve the minimum term for his crime. The factors defense counsel cites in their brief are compelling. The judge gave defendant the minimum. If there are no further questions, no questions with respect to the voir dire, I ask that you affirm and rest on my brief.
Thank you.
Thank you, Your Honors.
I just want to very briefly direct the court's attention to People versus Martinez, which we cited in our briefs. That was a case out of this court. And as I said, other courts have, other departments have also reduced sentences as cruel and unusual, and we would ask that the court do the same here. Thank you.
Thank you. Thank you both. Mazzarisi versus New York Society. Counsel.
Good afternoon, Your Honors. May it please the court. My name is Moses Ahn from the Grandelli firm, here on behalf of the plaintiff appellants, respondent Louis Mazzarisi and Danielle Mazzarisi. Simply stated, this case involves an accident where an HVAC service technician who specializes in servicing, repairing, and cleaning specialized equipment, including the chiller, the subject chiller.
So let me ask you a question. How does this not constitute a routine cleaning, but activity that would fall within 240 subsection 1?
Your Honor, routine as a matter of the definition of routine in terms of what Soto and the Court of Appeals discussed, it's a temporal routineness. It's a frequency routineness. That,
so once a year would not be enough?
Certainly, Your Honor. Basically, the court laid out daily, weekly.
Would it matter that it's routine inherent to the purpose of cleaning the HVAC? It's once a year. That's the requirement. So routinely, once a year, it's cleaned.
Your Honor, it's not frequently enough. That's the position, Your Honor. In this case, it wasn't even once a year. It wasn't a regularly scheduled maintenance. It was upon the call of HSS. Where the defendant would call Fresh Meadow and whatever company that they subcontracted out to come in and do this specialized cleaning of this condenser coil unit. It's a very different type of cleaning from what HSS personnel would engage in. Mr. Moran, the plant specialist, the plant manager, testified that he only saw one other time when that subject chiller machine was cleaned in a way of effective deep cleaning, and that was when Brian Thomas was cleaning it from the concrete floor without having removed any condenser coil covers. That brings this out of the quote-unquote routine maintenance that people would discuss. This required their expertise, the expert's structural knowledge of Mr. Mazzarisi, somebody in his position, and so this is certainly within the scope of the SOTO analysis and also in the
They
spirit.
set forth several factors, and it seems that this case would fall into most of those factors, would be applicable here, correct?
That's exactly right, Your Honor. And respectfully, I'm going to talk about Rukaj and Bragi. Their First Department cases, at least Bragi 1, was abrogated and modified by the Court of Appeals in 2007. But both of those cases discussed multiple factors for which the plaintiff's Labor Law 241 claims were dismissed, even though they were quote-unquote potentially cleaning cases. And both of them had a sole proximate cause factor in their dismissals. And in terms of Bragi, at least, the Court of Appeals, they abrogated the law relating to it has to be incidental to a construction or alteration or other enumerated activity. And so the spirit of Bragi, the spirit of SOTO, all of that is encompassed in the SOTO analysis. Basically, it's not just the one-size-fits-all. If a routine maintenance if a routine maintenance contract is existing, for instance, if a routine maintenance contract exists where a roof is supposed to be cleaned on an yearly basis of grime or snow or whatever it is. And I'm going to direct your attention to Ixcoy. It's a case where Judge Renwick, I think you were also subscribed to, and it involved a substantial height. It involved a cleaning, and it had nothing to do with some kind of alteration or some kind of repair. But this court decided that the plaintiff in Ixcoy was actually a cleaning covered under the cleaning statute of 241.
It was a little bit more involved. It wasn't a mere power washing. It was the technical tools and such that were used.
Well, there was power washing in this case, Your Honor.
Yes, no, I said it wasn't a mere power washing. Here, I'm not saying there's a mere power washing either. There required expertise that he had to be able to do it. I think
that's exactly right, Your Honor.
That's true in the other case.
And just turning to Labor Law 200, I think that's the low-bearing fruit, the low-hanging fruit. There is no dispute as to whether or not there was a negligent design or installation of the chillers. The metal grates structure the platform, Your Honors, if I may.
I'll just to wrap it up.
Sure. The platform was negligently installed, wherein there was not enough clearance. The manual itself said that instructed that there needed to be a 4-foot clearance on each side of the chillers. On the side that Mr. Mazzarisi was working on, there was only a 1-inch clearance, and that meant that in order to do the work that he was required to do, taking off the condenser coil covers and effecting the task that he was called to do, he needed to step up onto a ladder from the concrete structure, which was sloped, and which the
you have some rebuttal.
Knew about. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Jacqueline Mandel. I represent Hospital for Special Surgery in this case. Respectfully, our position is this is not a 240 case. In order for it to be a 240 case, the plaintiff has to be involved in a statutorily enumerated activity. This plaintiff was involved in doing preventative maintenance on the MRI chillers.
But the thing is, that's obviously what we were talking to your adversary about, and there have been cases, several cases, which say this is not routine maintenance, but this is a cleaning. The case of Ixcoy and the case of Fox, cases from this department, and when you look at the factors in SOTO, doesn't this take this case out of the routine maintenance and put it into cleaning, which would fall under 240 subsection 1?
Cleaning with special expertise.
I would say that this case does not satisfy any of the SOTO factors. If I may go through them quickly, First of all, one of the factors of SOTO, and let me preface that by saying that not any one of the SOTO factors is dispositive. We have to look at it in the context of all. So one of the SOTO factors is that the work has to be done in the context of either a construction or a renovation project, which we know was not going on. So that factor is not satisfied. Another factor is in SOTO is that it's not cleaning if no special equipment or expertise is required to do the job. So in this case, no special equipment. He's got stuff that any of us could go to Home Depot to get. He's got a ladder, he's got a spray washer, he's got a garden hose.
I don't think the fact that we could go to Home Depot and buy it makes it non-special.
No,
But in any case.
I'm talking about the specialized equipment, Your Honor. He didn't, have to come in with a bulldozer or scaffold or equipment.
But he had special expertise to be
Really
able to,
didn't
I
have-
couldn't do what he did with a power washer.
Your Honor,
The coils would be destroyed.
that may be true, Your Honor, but on page 156 of the record, he testified that he learned how to do this as he went along. Not only that, but his coworker, Mr. Humphreys, had never cleaned an MRI chiller before, and Mr. Mazzarisi taught him that night, and Mr. Humphreys was able to go and do it. So I would say that while you and I don't know how to do it as we stand here, if somebody was standing there saying, this is where you spray it, we would be able to do it because Mr. Humphreys could do it. So I don't think that he satisfies that criteria. The next criteria is that it's not cleaning unless the activity involves a significant elevation risk and can't be an elevation risk that's comparable to domestic cleaning. What we know from this record is that this plaintiff was no more than 36 inches off the ground. At most, he was on the third rung of a ladder. That's the same as if I stand on the step ladder that I need at my height to reach the highest shelf in my kitchen cabinet. So we do not have a significant elevation risk here. The last factor has to do with whether or not this is done on a recurring basis. It doesn't matter if it's once a year or not. I would refer the court to the Second Department decision that's almost exactly on point. It's cited in my brief. The name of the case is Sobenis, and it'd be helpful to have my glasses. In the Sobenis case, the plaintiff he fell from a ladder while he was working on a building's air conditioning system. And the Second Department held that the plaintiff was performing annual service of the air conditioning system done at the end of every cooling season to ensure that the system continued to function effectively, and thus he was really engaged in only routine maintenance. That's what was going on here. There's a preventative maintenance contract. There's testimony from the plaintiff's own boss. He says it multiple times in the record on page 628 and 629. On page 648, was this just routine preventative maintenance? Yes. Was it done pursuant to the preventative maintenance contract? Yes. And so, the plaintiff can call it cleaning if he wants to, but cleaning would be, within the meaning of Labor Law 240, would be a roof shampoo. You have to be licensed to get up on a roof. That's a significant height. You need special equipment to shampoo a roof. This guy used a power washer and a garden hose.
Well, I mean, as a result, I appreciate the Second Department case. We're not bound by that. We don't.
Of course.
We have the Ixcoy case where we've really found that power washing in the commercial setting would qualify as cleaning.
But it has to meet all of the SOTO factors, Your Honor.
Well, it doesn't have to meet all of the SOTO factors, and you skipped one, which I think is a pretty important one, which is the one that says, in light of the core purpose of Labor Law 240 subsection 1 to protect construction workers, I think that's an important characteristic. I don't think you can say that falls out, and I think it does fall into the commercial power washing, but I see your time's up.
Your Honor, if I may just answer the...
I'll give you 15 seconds to answer.
Thank you, Your Honor. Judge Kapnick, you decided in 2019, in fact, I think you were the presiding judge on Cologne versus 3rd Avenue Open MRI. This is a case cited in my brief. And in that case, you held that the plaintiff, who was injured when he fell from a 6-foot A-frame ladder in an MRI facility, that the plaintiff was engaged in routine maintenance rather than repairing,
He
and
wasn't power washing the coils and partially inside, outside. I think was a very different scenario.
Thank you.
Thank you.
If I may, Your Honor. Yes, Your Honor. In terms of Cologne versus Third Avenue, just to clarify, it was a repair alteration analysis, and so routine maintenance, that phraseology would actually have applied in that case. This is a cleaning case. That's why Soto and Bragi exist. If there was a routine maintenance standard in cleaning, then that would abrogate, that would obviate the need of Bragi, Soto, and that whole analysis.
We're going to have labor law cases for the rest of our existence because every single one has a little bit of a different twist, I know, so.
That's fair, Your Honor. That is very true. In terms of the no expertise, that's a little disingenuous based on the record. The record indicates that my client.
You don't think Judge Renwick and I can go clean the coils now?
Your Honor, respectfully, plaintiff Mr. Mazzarisi had engaged in chiller, this specific type of MRI chiller coil, not chiller air duct and chiller pipes, because that's what Mr. Humphreys was expertise in. Mr. Mazzarisi was expert, and he had done 10 prior chiller condensed chiller coil cleanings previously. And this is exactly why he was hired as a journeyman, not as a novice apprentice. He was hired as a journeyman who had several years of experience doing exactly the type of expert cleaning that was required in this case. Thank you, Your Honor.
Thank you. Thank you both. Petri versus Lucia. Mr. Petri, good afternoon. You're pro se. There's no opposition. So you tell us in the time that's allotted what it is that you want us to find, what happened and what you want us to conclude.
What I like is, I respectfully ask this court that the lower court order to be reversed and the matter to be remitted to the lower court to enter a default judgment against the respondents on the issue of liability. The respondents failed to appear and answer in the lower court as just they did in this court. Based on the laws, I submitted to the court a notice of motion for default judgment, which the lower court denied and inappropriately advocated on defendant's behalf. To cover the reason of denial, the court came with 3 reasons. The first reason was that the respondents, to establish a proof of claim, plaintiff must submit an affidavit or verified complaint from someone with personal knowledge. The CPLR 3215F is saying that not someone has to submit an affidavit, but the party or the party's attorney. What is very interesting is that the court, when I mentioned this reason, they presented a case, Zednik versus Biderman Inc. USA, where the High Court say, however, judgment by default further require proof of affidavit made by the party and facts constituting the claim, the default, and the amount due, or at least verified complaint. The plaintiff, when submitted the complaint, submitted the affidavit, the summons, has also submitted a verified complaint. The judge didn't take in consideration the verified complaint, which is an affidavit, which is notarized and is signed. The second reason that the court denied the default judgment was plaintiff attachment of the affidavit in support was not signed and notarized. Well, the affidavit in support is a 2-page form. On the second page, everyone has to sign notarized. The plaintiff signed notarized that second page, and of course, that signing notarized in the page include all the entire package, which is include the attachment also.
Thank you. Thank you very much. We have your record, and we'll take a very good look at it. Thank you very much.
I want to say the last one, ma'am. The last reason, which is also is not correct, the court stated that the plaintiff and process server's affidavit of military service doesn't prove any investigation into defendant's military status, which is incorrect. The court cited Title 50 of United States Code Section 3931, which is saying that it's not necessary for a plaintiff which submitted the full judgment motion to have any investigation into the defendant's military status.
Thank you.
Thank you, ma'am.
Thank you.
Thank you. Have a nice day.
140 West 57th Street versus Berry.
Good afternoon, and may it please the court. My name is Jesse Loeffler on behalf of Plaintiff Appellant 140 West 57th Street Building, LLC. The trial court's holding should be reversed in its entirety, both with respect to the denial of plaintiff's partial motion for summary judgment and in granting defendant's cross motion dismissing the entire case on a limited record before discovery was done and on the basis of a purportedly senior security interest that no longer even existed at the time certain fraudulent conveyances that were not before the court on our partial motion for summary judgment occurred. And I'll take the court through the transactions that were before the trial court and then this security interest. First, there were a set of 3 insider related party interest payments made from...
Can I ask you something? It seemed like the court, the trial court, did not give any credence to your accountant's affidavit, Mr. Polanski's affidavit. And did he think he didn't qualify as an accountant? What was the problem here?
So I think what the trial court believed is Mr. Polanski, and again, he has been a forensic accountant for 50 years. He's been involved in many a case. He sets all of this forth in his affidavit, which were lengthy and supported by 200 pages of exhibits. I think what the trial court had an issue with was Mr. Polanski goes through both book value and saleable value for purposes of his solvency analysis. Book value is easy. He just takes what's on the books and records listed as assets and liabilities. Saleable value, I think what the trial court was expecting him to do is say, I'm an accountant with expertise in figuring out what the saleable value of goods in this type of industry, a high-end stationery store, is. But that's not what Mr. Polanski did. What he did is go use the defendant's own books and records to figure out what the gross profit margins were and say, here is what their saleable value based on their own historical and contemporaneous profit margins are. Mr. Polanski wasn't just making up a new formula or figuring out, this type of stationery has a saleable value of X or Y. He was using the defendant's own numbers.
Did the defendant put forth an expert affidavit from an accountant? I didn't think I saw it.
No, they did not. We put in our expert. They did not challenge, interestingly, they did not challenge Mr. Polanski's qualifications at the time. And then they didn't put any evidence of solvency themselves, which in the Flowers v. 73rd Townhouse case decided by this court on February 1, it's 2022 Westlaw 287522, the court was confronted with something very similar, which was the defendant didn't put on any evidence of solvency and didn't bear their burden. The same applies here. We think the solvency analysis was valid and they were insolvent. And they admit that they were insolvent in connection with their arguments about this senior flax security interest.
That security interest, which I'll let you explain how you think it doesn't exist, but wasn't that for just a very small portion? That was like $175,000 or $200,000. The judgment that you have is over $2 million. Am I correct?
That's correct. When you look at the flax security interest, it was, I think it was December 2008 when it came into existence. It was paid off totally by January 9, 2014, according to the records they put before the court. But when you compare each time period...
Doesn't the court dismiss some of your claims based on the flax security interest, which arose after after its expiration in December of 2013.
That's correct. In November 2014, we identified, and these weren't before the trial court, there was effectively, we got our judgment, the underlying judgment, on October 15th, 2014, and lo and behold, 2 weeks later, Kate's Papery, the judgment debtor, essentially consolidates into this 188 Lafayette entity. They have hundreds of thousands of dollars of paper goods, books, calendars, stationery, that all of a sudden disappears. And at this time, the Flax security interest no longer exists. It's been satisfied. So we would submit that regardless of what you believe about the interest payments or the earlier 2012 RTBI security interest, how can the Flax security interest possibly block plaintiff's recovery for these additional November 2014 transfers that are still a question of fact because we never had depositions yet in this case, and the defendants have essentially said, those were our assets. They went to 188 Lafayette. They tried to get an OSC to prevent our attachment of those assets, and then when they lost that motion right after our judgment, all of a sudden, oh, well, those assets weren't from Kate's Papery. So we're still tracking those assets. Thank you, Your Honors.
May it please the court, David Gillette for respondents. I've got a lot of ground to cover here. There are only 4 transfers that the plaintiff identified before the trial court. 3 of them were interest payments from Kate's to RTBI. RTBI transferred those back. Those were all conveyances under our DCL 270. The transfers from Kate's to RTBI were conveyances. The transfers back from RTBI to Kate's were conveyances. So those conveyances were undone, and we maintain that, therefore, those claims are moot. The 4th transfer was a pre-litigation, was a security interest which Kate's granted to RTBI that lapsed in 2017. So that's moot. I mean, you can't set aside a security interest that lapsed 5 years ago. There's no allegation that any secured assets were ever transferred while that security interest was in effect.
Well, why should the court have thrown out all of their causes of action under a fraudulent conveyance claim?
I'm getting there, Your Honor. I'd like to turn to that next. So we've got these allegations of other transfers so all the allegations of transfers are from Kate's 2088. They fall into 3 categories. The first category is allegations that Kate's transferred its entire business to 188. Okay, that's the allegation is debtor vacated the premises in January of 2011. That's at R33 and R47. That's an important date, January 2011. The allegation is then that with respect to 188 Lafayette Street, the new location, to which location it appeared that judgment debtor had simply moved its operations, merchandise, and assets from the premises leased from plaintiff and reestablished itself under a new entity, 188 Lafayette. That's at appellant's brief at page 12. I'd like the court to take judicial notice that 188 Lafayette LLC was formed 2 years later on September 26, 2012. So there's no way that Kate's vacated in January 2011 and transferred its assets at that time to 188 Lafayette, which didn't exist. Judicial notice of Department of State website can be taken under Lassonde against Seabrook, 8983rd 132, footnote 8, First Department, 2011. The second of the 3 categories of transfers was that Kate's consolidated or merged with 188. The allegations in late 2014 or early 2015, judgment debtor ceased operations and apparently merged with 188. Appellant's brief at 3. There's no record evidence of any merger or consolidation, and appellant knows that Kate's didn't merge or consolidate into 188 LLC, Lafayette LLC, in 2014 or 2015 because appellant obtained a turnover order against the Kate's bank account in January of 2016. That's at R20. Also, I'd like the court to take judicial notice that Kate's Papery LLC and KP Creative Ltd still exist. So there was no merger or consolidation. The third category of transfer that plaintiff alleges is that Kate's transferred assets to 188 Lafayette LLC later in 2014 and 2015. Appellant's brief at page 18 cites record 647 to 654, a 2014 balance sheet attached to the Polanski affidavit. The balance sheet doesn't indicate there was any transfer. The Polanski affidavit is silent about any transfer. Turning to the Polanski affidavit, there's a standard of review for when a motion court decides not to qualify an expert to testify. And that is that a trial court has to make a serious mistake or commit an error of law or abuse his discretion. Meiselman against Crown Heights
You
Hospital.
didn't even put in any kind of affidavit to oppose Mr. Polanski's affidavit. He's been a certified public accountant and a principal in a law firm. How do you just ignore his affidavit?
Your Honor, he has to qualify. So it's not up to us to...
qualify where? I mean, this wasn't a trial, it's a summary judgment motion. You put in an affidavit of your expert.
Puts in an affidavit, and I'll tell you what, there's a lot of problems with that affidavit. First off,
Why didn't you put in an affidavit of an expert to?
Well, but they didn't, they said they were going to show insolvency, and they failed. And here's why. Okay, appellant tries to burnish Polanski's credentials by saying that he's had over 5 decades of experience as a forensic accountant. They put that in quotes as if that's something that Polanski said in their brief at 37, but it's not what he says. He says he's been a CPA since 1968, R597, paragraph 3, decades of experience in the field of accounting, in paragraph 4, and was retained by appellant in my capacity as an expert in the field of accounting, R599, paragraph 11. He doesn't say he has practiced forensic
accounting. Well, doesn't that go to the weight
1968.
as opposed to the admissibility of his testimony when
Problem
you have an
is,
expert?
Your Honor, the problem is that there's a standard of review here, and the appellant ignored the standard of review. In Nemeth against Brentag North America, 183, 83rd, 2011, the trial court found that the expert lacked professional qualifications, and the court said on appeal, quote, although plaintiff expresses dissatisfaction with the trial court's ruling, no actual legal argument is raised challenging it, and plaintiff has therefore abandoned whatever argument it may have had regarding that ruling.
Thank
you. It was
you.
up to appellant to
Counsel, thank you.
identify the legal standard and say that it wasn't satisfied, which they failed to do. I have more, but I see that my time is up.
Thank you.
Thank you.
Thank you, Your Honors. I'll just make a few quick points in response. First, with respect to these other transactions in late 2014, what is clear is that Kate's Papery had some assets. We were tracking them. We're not through discovery yet. We haven't deposed Ms. Berry yet. They had assets and then they didn't. And I'm hearing a lot of speculation about, merger and consolidation of these entities. I don't think that's a relevant fact here. The issue is we're tracking assets that were transferred. We know from their records, and it was pointed out, our record, page 647 through 650. We know there were assets that disappeared after the time of the Flax security interest was satisfied. That is why the trial court's decision has to be clear error. It's just simply not, there was no senior lien in effect at that time period, regardless of what you believe about the interest payments or
What's
this.
the story with the RTBI security interests? Where does that fall into this picture?
So in May 2012, shortly after we commenced our underlying action, the RTBI, which is the sole member of Kate's Papery, signs a little amendment to their previously unsecured loan and gives themselves a secured interest. So they've converted an unsecured note into a secured one, and our position.
Do that?
Pardon me?
Are they allowed to do that under the law?
We say no, and we cite a number of cases in our briefs that say even if you are transferring a security interest for an antecedent debt, if it's done by insiders, it lacks fair consideration as a matter of law. And that was the 112 West 34th Street case we cited, talks about where even if you are, a corporate insider is on both sides of the transaction, as a matter of law, it lacks the good faith prong of fair consideration under the DCL.
Thank you.
Thank you.
Thank you both. Roberts versus Rogers and Hammerstein?
Good afternoon, Your Honors. David Leichtman from Leichtman Law on behalf of Chapman Roberts. Your Honors, arbitration is a matter of consent, not coercion. And in this case, what we have is two agreements, one of which our client is a party to, but none of the defendants are a party to. And the question is whether or not that agreement was assigned to one of the defendant groups.
So you didn't put in a copy of the assignment, and neither did they, right? Nobody put in a copy of this alleged assignment, correct?
Correct, because what happened...
Before we go any further, I'm going to ask you to put your mask up, please.
Yes. What happened was there's a separate copyright lawsuit pending in federal court. And we were told during the course of that action that there was an assignment of this agreement. And then we were asking for it, and no one ever produced it to us. So the defendants haven't put it into the record. And so even though they're claiming there was an assignment, we've never seen it, and there's no evidence of it in the record.
Well, of course, you're obviously full aware of the main agreement that was very broad in what it included with regard to arbitration. Is it likely that that agreement would have been assigned without all of it being assigned, the right to arbitration as well?
Well, there's an assignment clause in that agreement.
Yes, sure.
At paragraph 12, and
Absolutely.
at paragraph 12 it says you can assign part.
Yes, it does say that.
Or all of the agreement. And
what would the purpose of assigning part of it be?
Well, in particular, if you look at the record at page 268, which is a 1996 amendment to the 1994 vocal arranger agreement, there's paragraph 3.1. And in paragraph 3.1, the Broadway producer explains that certain rights may revert back to Lieber and Stoller after the Broadway production closes. It doesn't say there's going to be an assignment. And so what makes sense, and the reason why I think our position is correct, is that Lieber and Stoller would need the rights to the musical to revert back to them so that they could further exploit it.
Let's go back to the night. All of your rights here, all of plaintiffs' rights to compensation stem from paragraph 11 on page 265 of the record. Isn't that so?
Not exactly, because...
You mean you have a right to be paid other than the fact that paragraph 11...
Yeah, yes, because our client is the property owner. Our client is the intellectual property owner, the copyright owner, and the vocal
But your right to payment comes from the 1994 agreement. There's a 1996 agreement, but it all starts with the 1994 agreement.
Well, in the 1994 agreement, there is a limitation on his right to collect on his copyright interests, and that is where the compensation comes from. That's true. But that's merely a limitation.
So you've agreed, he agreed in paragraph 11 to the broadest of arbitration clauses.
Only with the other party to the agreement, which was the Broadway producer, not the songwriters. So he never...
But the thing is, if they transfer it to somebody else, now you want to recover from them, so that's part of the agreement. You can't enforce part of the agreement and then say, oh, but the arbitration part, sorry, that's off the table.
Only if there was actually a transfer, and we have no evidence of that. And that's our whole point.
So if there's no transfer of this agreement, then you don't have a right to recover from anybody except this original Broadway producers, which I don't know if they exist anymore.
Well, then we would still have our money had and received claim and our unjust enrichment claim, right? But we never got to the merits of that question, Your Honor, because we were ordered to arbitrate, and my client simply can't afford to arbitrate at, 78 years old. So the fact of the matter is that
There's a question here from.
In your original complaint, paragraph 47, you allege that as a result of the assignment of the entire vocal arrangement agreement to the LNS respondents, and what we have here, let me interrupt my own quotation there. LNS assigns or sells, whatever you want to call it, to RNH. But so getting back to your original complaint, the entire vocal arrangement agreement to the LNS respondents are the direct successors and interest to the vocal arrangement agreement and agree to undertake all of the producer's obligations to plaintiff under the vocal arrangement agreement. In your first amended complaint, paragraph 46, what you alleged was that the RNH agreement expressly incorporated the payment obligations of the vocal arrangement agreement, imposing the payment obligations on the RNH defendants. Thus, by the plain language of the RNH agreement and the intent of the parties, the payment obligations to Roberts in the RNH agreement were intended for the benefit of Roberts. So it all comes back to that original agreement, and your original allegations said as much, but then, and I know this is your adversary claims that when they approached you on this subject and said, look, there's arbitration here, let's go to arbitration, you then pulled back on that allegation and came in with a new version of the complaint. But it all still comes back to this broad arbitration agreement.
Yes, may I answer?
Of course.
Okay. So if you look actually at footnote 2 in our amended complaint, which hangs off of paragraph 42 at the record at page 70, we explain there that the reason why we made that allegation originally in our original complaint was because they had told us there was an assignment. And then we asked them for the assignment, and they never produced the assignment. And so in the discussion back and forth about what exactly our client was seeking recompense for, and that's exhibits A through T, I think, of my declaration, which is in the record, they never produced anything. They never provided any proof of what they had said.
I know Judge Renwick was asking you about this, but can you suggest to us why whoever was assigning this would assign the agreement but not assign the arbitration provision?
Yes, and so let me, I was trying to answer that earlier, I apologize. So again, if you go to paragraph 3.1 of the 1996 amendment, for the first time, this is now 2 years after my client had actually done the work that was associated with the musical, the producers tell him the rights, not to his vocal arrangements, but the rights to the musical are going to revert back to Lieber and Stoller at some point in time. And the last sentence of that says, producer further agrees to advise the authors that such negotiations should be undertaken in advance of the use of the vocal arrangements, and that negotiation never took place. So our client had no knowledge of what happened after the Broadway musical closed. Now, if you look at the record at page 126, this is an Exhibit A to the agreement between the defendants, between the Lieber and Stoller defendants on the one hand and the Rogers and Hammerstein defendants on the other hand. And they attached to it a 1992 agreement, which preceded my client's 1994 agreement between the Broadway producers, which is L&S Company Broadway Limited, on the one hand, and Jerry Lieber and Mike Stoller on the other hand. And so what I think actually happened here, and again, the defendants know this. They could have put an affidavit into the record. They could have put a document into the record, but they didn't do it. What I think what happened was the 1992 agreement between the Broadway producers and Lieber and Stoller said, at the end of the Broadway run, the rights to produce the musical will revert back to Lieber and Stoller. But nobody ever addressed the vocal arrangements. However, in the Rogers and Hammerstein agreement at paragraph 1.1 on page 107 of the record, Lieber and Stoller then gives Rogers and Hammerstein the right to license our client's vocal arrangements. But nobody ever came to my client and said, is it okay if we do that? And so
Thank you. I think we should hear from the other parties now, and you have rebuttal.
Thank you, Your Honors. Matthew Geiger from Rosenberg, Geiger, and Perla on behalf of the Lieber and Stoller respondents. Mr. Roberts has, and his counsel have tried to complicate and obfuscate,
How come you never produced this assignment agreement, the assignment?
Your Honor, the assignment does not matter. They've tried to complicate and obfuscate what is really a simple issue.
Do you have the assignment?
Do we have an assignment? There are many agreements that concern the creation.
I think maybe answer the
musical.
question is, how come you didn't produce it?
We didn't produce it because we've been involved in litigation with this plaintiff for some time. There was no discovery, and every time we produce a document to them, they start a new case. And we decided that we didn't need to produce a document that was irrelevant to the case.
You have the document?
Excuse me, Your Honor?
Does the document exist? Do you have it?
I don't believe there is an assignment document, no. That is on its face an assignment. But what there is, as plaintiff's counsel has stated, an understanding from everyone that the rights in this case, the rights in the musical would revert from the Broadway producers to the Lieber and Stoller parties. And that's what happened here.
What about but doesn't he have separate and independent rights to the vocal arrangements, and that's something different than the rights to the musical?
The vocal arrangements are arrangements of songs written by Lieber and Stoller. He has an agreement with the Broadway producers regarding the creation of the vocal arrangements, which includes a right to be paid on certain performances of the musical.
Okay.
And to be credited. This case is a contract case. It has nothing to do with copyright. There's no copyright claim in this case at all. He does claim...
I mean, it seems like he hasn't gotten paid since the Broadway show closed.
He was paid for... There's different types of performances. There are what's called stock and amateur performances.
Okay, I got it.
His rights in stock and amateur performances were bought out. So he was paid a flat amount for stock and amateur performances in the United States, okay? Rogers and Hammerstein exploits the many musicals and licenses them for stock and amateur performances as well as other types of performances. So if this case proceeds at arbitration, the issues will be whether or not the performances that are at issue were in fact stock and amateur, in which case he has no right to be paid, whether or not they were in the United States or outside of the United States, whether he had a right to be credited or not, because the credit right...
Who's gonna pay him? Your client?
Should he prevail on his claims, yes. He has asserted claims under a contract that includes an arbitration clause.
I understand that, I've read
governs
it.
his claims against our clients. He's asserting that this contract binds us, and it doesn't matter whether we received an assignment, whether he has that assignment. We cited many cases in our brief, we have a right to invoke the arbitration clause, and he, as somebody who signed a contract and agreed to arbitrate these very claims, cannot somehow assert certain claims under the agreement for payment obligation.
Even though the arbitration agreement is not with your client?
Correct. There are many cases in New York where a non-signatory to an agreement containing an arbitration clause nonetheless is able to compel arbitration.
Because it gets assigned, but you're saying, well, we don't exactly have an assignment. It's an understanding.
There are cases where the contract hasn't been assigned and a third party who is sued, as long as they're sued as a plaintiff is pursuing a contract with an arbitration clause for enforcement of that contract, that's really the only question.
Did the LNS to RH agreement incorporate the 1994 agreement?
I'm sorry, Your Honor, could you restate
The LS to RS, assignment or agreement, whatever you want to call it.
R&H.
Yeah.
R&H, I'm sorry. Did that incorporate the 1994 agreement?
Did it incorporate it? It did provide certain requirements of payments to Mr. Roberts in that agreement, yes.
From
It
the
didn't,
1994 agreement?
requiring a R&H to pay Mr. Roberts for certain performances, certain
That
types.
provision was put in there directly for his benefit.
I would say that is, yes, but for the Lieber and Stoller respondents, we're talking about the original vocal arranger contract, and we're invoking that arbitration clause under the original contract between Mr. Roberts and the producers. We, as he has alleged, as inheritors of the obligations under that contract, have a right to hold him to his agreement to arbitrate the claims, the very claims that he asserts in this case.
Thank you.
Thank you.
Good afternoon. May it please the court. I'm Robert Besser, representing the R&H defendants. And I have just a very simple statement to make. The R&H contract, which you just raised, does provide that R&H will make certain payments to Mr. Roberts, to the plaintiff. It also provides for an arbitration.
Do we have a copy of that agreement in the record?
Certainly do. It begins at, I believe it begins at page 102 or 3 of the agreement. Well, actually, no.
The plaintiff is not a party to that agreement, of course.
No, the plaintiff is the third-party beneficiary. He's specifically named. He sued us.
He's named
under the
in that
theory.
agreement.
Yes.
That's between LNS and you.
Yes. And it says we will make certain payments to Mr. Roberts. Mr. Roberts is a third-party beneficiary. He sued us on that contract. He has no other claim against R&H except on that contract, which provides for an arbitration clause. And as a third-party beneficiary,
Well, it
under
doesn't
the
provide
cases,
for an arbitration clause between R&H and him. Because he's not a party to it.
he's a third-party beneficiary to the contract between R&H and LNS. And that portion, I mean, that contract,
Okay,
this contract
I get
we're talking-
that.
has an arbitration
That is,
clause.
as a third-party beneficiary, is covered by that arbitration provision. But also, under that agreement, where does his right to compensation come from? Why did R&H agree to be paying him?
Because we were advised by Lieber and Stoller that he was entitled to $250 per 8 show weeks, whatever the...
Coming from where?
Excuse me?
Coming from where? Why was he entitled to it?
Because he was the vocal arranger, and that was his contract with the producers.
The 1994 agreement?
Yes.
Okay, so what that says is any dispute arising under, out of, or in relation to this agreement goes to arbitration.
I'm sorry, I missed the first part of what you
Any dispute arising under, out of, this is not a hostile question.
Right.
Any dispute arising under, out of, or in relation to this agreement
goes to arbitration. And that's what we asked for, an order directing it to go to arbitration, correct. We believe that's where it belongs.
Okay, thank you.
Thank you.
I was hoping somebody was going to play music.
Thank you, Your Honors. So first, to address the Lieber and Stoller argument, this so-called understanding that somebody might have had at some point, again, there's no evidence in the record of that. Certainly, our client had no knowledge of that.
Counsel, I would like for you to address the issue of being the third-party beneficiary to the R&H agreement.
Sure. So here's the standard. The standard is you have to have a direct benefit and a knowing exploitation of the agreement, right? And so what that requires is our client would have had to have knowledge of the R&H agreement between R&H and LNS. He would have had to have a knowing acceptance of some benefit from that agreement, which he's never been paid a nickel under. And
That's why you're suing him, because you want to get a
That's right.
nickel,
That's
probably
right.
a little bit more than a nickel.
But the case law that we cited in our brief, Your Honors, basically says that just alleging you're a third-party beneficiary alone and it having some interrelatedness alone is not enough. There has to have been a knowing exploitation of it and a direct benefit. And my client hasn't gotten any benefit from it whatsoever, and he didn't even know about the agreement. So he can't be bound to an arbitration clause in an agreement he didn't even know about. And Your Honor, just to address your point about the arbitration clause in the vocal arranger agreement from 1994, what it says is that an award will be rendered inconclusive upon the parties. And these other folks were not even parties to this agreement, and as they've now conceded, there was never an assignment of this agreement.
In relation to this agreement.
Right, but you have to read the last part of it, which is, says any award rendered shall be final and conclusive upon the parties. And they weren't parties. And our client never had any knowledge that, some part of the rights had been assigned or not. And we will concede that they probably got some reversion of rights, but a reversion of rights is not the same thing as an assignment under the case law. And all the cases basically say you have to have a knowing exploitation and a direct benefit, and our client had neither.
Thank you all.
Thank you.